Yes.
Lordship, I like to mention item number 33 of daily list, Lordship. Lordship, some personal inconvenience is on my part, Lordship. Matter me password for the day, Lordship.
You are for
Petitioner, Lordship.
33.
33, Lordship.
Mr.
SN Krishna Traya.
Krishna
Krishna
Traya.
Traya.
Learn counsel for the previous submits that he has some difficulty to the list of therefore correspond listing of the matter after
After
3 weeks. Praise the Lord. List after 3 weeks.
And Lordship, I have a similar prayer, Lordship, with respect to item number 57. Here, Lordship, I am appearing on behalf of Mr. PJ Fukon, Lordship, standing counsel Guwahati, Lordship, on the with the concern of the petitioner side, Lordship.
On the consent of the learned counsel for the petitioner, Mr. So-and-so, learned counsel, appearing on behalf of Mr. Fukon.
Yes, Lordship.
PJ Fukon, learned counsel for the
Guwahati University, Lordship.
Guwahati University. Praise for adjournment of the matter.
Lordship, if possible, Lordship, petitioners have placed a request. If possible, can it be on 25th, Lordship, or 26th?
After 2 weeks. Huh? Praise the Lord, list after 2 weeks.
May I please, Lordship? My Lord, I have prayer in item 48, my Lord. Orders item. My Lord, I am for the petitioner, my Lord. The steps upon all the respondents have been completed, my Lord.
We'll see.
Lord.
Orders we'll see.
Lavazima court order, I have checked, my Lord. 12/11/2024.
So,
The steps upon respondent number, all the respondents have been completed. Lordship will kindly post this case just after 2 weeks in admission column, my Lord. That
we'll
is my
see.
prayer.
We'll see. We'll pass the orders. You be there.
My
Lord.
May I please, Your Lordship? Your Lordship, I beg to mention item number 31 and 32, Your Lordship. Your Lordship, similar matters are pending before the Honorable Court of Court number 4, Your Lordship, and that matters are fixed on 25th, Your
31
Lordship.
and
I am for the petitioner, Your Lordship.
31 and
32, Your Lordship.
33.
32.
Okay. You are for petitioner.
Yes, Your Lordship.
M. Ahmed.
IAS Laskar.
I.H. Laskar, and concept of the petitioner submits them. The analogous matter are being taken up before the court number 4. Court number 4.
Yes, Your Lordship.
Therefore, praise the matter will be listed after 3 weeks. Praise the Lord, list after 3 weeks.
Hi, Your Lordship.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 25 of today's daily list. In this case, I am for the respond number 5, madam. We are yet to file our affidavit in opposition, madam. We need further 10 days time, madam, to file our affidavit, madam. Kindly check up this.
2022, we are yet to file the affidavit. Mr.
S. Hazarika.
S. Hazarika, learned counsel for the
Respond number 5, madam.
respond number 5. Press for and is granted 2 weeks time to 3 weeks time, 2 weeks.
2 weeks.
2 weeks time to file affidavit in opposition.
Lordship, interim may be continued, Your Lordship.
Mr. So-and-so, learned counsel for the petitioner is present. Interim order first, earlier will continue.
There's an urgency in respect of respond number
2 weeks, we'll see after 2 weeks. What is the matter?
matter, Lordship. Because of the fight between the petitioner and the respond number 5, I am hang up, Lordship. He has no, Lordship, he has not challenged my provincialization. But
Okay.
still, Lordship, because of the
We'll see.
May it please, Your Lordship. So I beg to mention item number 19. With the consent of other side and appearing on behalf of Mr. N.K. Kolita. With some difficulties to this.
On the ground that Mr. N.K. Kolita, the counsel for the petitioner has some personal difficulty today, Mr.
Dide.
Huh?
Dide color.
D. Deka, then counsel. Press for adjournment of the matter. Praise the Lord, list after
2 weeks, Lordship.
2 weeks.
May it please, Lordship.
Lordship, item number 44, Lordship. As per the last order, 4 weeks time was given for the health department to obtain the instruction. And this morning, Lordship, I got informed that they require another 2 weeks time to obtain their instruction, Lordship. Health department, Lordship. So they matter may be taken up after 2 weeks, Lordship.
We have no idea.
Lordship, I have another item 14.
Okay. That on the prayer of Mr.
PJ Das.
P.J.
Das.
Thus, learn counsel for the petitioner. List this matter after 3 weeks.
Lordship, kindly fix a date, Lordship. So, then the next occasion it will dispose of, Lordship.
We'll see.
God bless you.
Lordship, item 14, on behalf of respondent number 2, ASIDC, we have taken consent of the petitioner side.
Item 14,
Item 14.
yes.
Respondent number 2, ASIDC, we have taken consent of petitioner side. Matter may be adjourned for the day
On the
and
prayer of Mr.
ASUD,
Learned Counsel for the respondents.
respondent 2, ASIDC.
Respondents ASIDC, list this matter after 4 weeks,
1 week, sir.
3 weeks, 2 weeks.
1 week, 1 week.
Why? After a week. For what?
Yes,
For
personally,
filing affidavit. So it's to enable him to file affidavit in opposition.
May it please your lordship. Well, item number 10.
Hmm.
I appear for the petitioner, my lord.
Hmm.
My lord, there's a similar matter, WPC 3975 of 18. It's an identical matter under consideration, my lord.
Hmm.
It needs to be tagged. I could not find a government council to take the consent. Otherwise, anyways, could it be tagged with WPC 3975 of 18?
Mr. S. Banik, Learned Counsel for the petitioner submits that there is one no.
Similar matter.
Huh?
Similar consideration.
One similar matter pending before this. Similar matter pending before this court. So, therefore, that matter may be listed along with.
WPC 3975 of 2018.
Second,
Accordingly, it may be adjourned.
and praise for adjournment. List of praise the Lord. List after 3 weeks along with WPC numbers for instructions. Huh?
I'm grateful, my lord. Obliged.
May I please your lordship? Lordship, I beg to mention item number 40. The conducting counsel, Mr. B.M. Decker, is slightly out of session, lordship.
40.
Lordship.
Hmm?
Yes, your lordship.
Why is he out of the station?
Lordship, he is currently in under bench, lordship.
Huh?
Cases. He is appearing in some other bench, lordship.
That on that ground, can you be adjourned the matter
Lordship,
Anyway,
kindly pass the matter for the
on the prayer of Mr.
I am Alam.
Huh?
I am Alam. Lordship.
M. Alam, Learned Counsel for appearing on behalf of
Mr. B.M. Decker.
Mr. B.M. Decker, Learned Counsel for release this matter after 4 weeks.
May I please,
May please, Lord.
my lord, item number 57.
Hmm.
57, my lord, lordship, other side advocate probably has mentioned. But there is a, my lord, the conversation with the other side advocate that the matter is urgency. For that reason, my lord, the petitioner approached before the Supreme Court. And Supreme Court, my lord, given a direction to expeditious hearing. So my matter may be, my lord, fixed on 25th, my lord.
We have fixed it after 2 weeks.
No, my lord, this is the urgency, the order is there, my lord. That is why I am pressing, my lord. Kindly.
See, the matter.
I my lord, express my opinion that will be fixed on 25th. If it is not fixed on 25th, my lord, the order, but that is there, but that is why I am saying, my lord. The urgency there, matter is pending for since long for a small issue. Institution, my lord, the students are suffering. My humble prayer, my lord, on 25th may be fixed, my lord.
Consider the feasibility of expediting the hearing of the matter. Yes, after 2 weeks.
My lord, date may be fixed, my lord, otherwise it is very difficult, my lord.
I thought it is fixed on 25th.
25th, my lord. 25th
Supreme
of,
Court has fixed the matter on 25th.
my lord.
Supreme Court has fixed the matter
No,
for hearing.
Supreme Court has not fixed, my lord. The feasibility, my lord, because the matter petitioner approached.
What is the matter?
Matter is what relating to NOC issued from the government in respect of the private college, private law college. Law college is private law college, library, any institution. NOC is not required from the government, but affiliation is not granted on that ground by the university. For that reason, my lord,
Give the date.
my
2
lord,
weeks, give the date.
my lord.
2 weeks.
But
Take the date from there.
May please, your lordship.
What-
May please, lordship.
Yes.
First, I beg to mention item number 39, lordship. 39. The respondent has filed the affidavit yesterday, lordship. So,
Mr.
C. Kumar, lordship.
C. Kumar, Learned Counsel for the petitioner submits that
We are about to file our
he
affidavit
may
reply,
be
lordship.
granted 2 weeks time to file affidavit.
3 weeks, lordship. Can it be after Bihu, lordship? My CV will be after.
3 weeks time for filing affidavit in reply. Mr. President, list up to 3 weeks.
I'm a very
Obliged.
quick respondent.
I'm waiting for the response.
Obliged, Lordship.
May it please your lordship. Lordship, in item number 18, I was referred to file an affidavit in reply, lordship.
18,
18, lordship.
on the prayer of Mr.
M. Bhagavati.
M. Bhagavati, learned counsel for the petitioner. But the 2 weeks time, 3 weeks time is granted to file affidavit in reply.
May it please. Much obliged.
Lordship, beg to mention item number 13 for adjournment. Lordship, I appear for the petitioners. The government, they have filed an affidavit. I'll have to obtain certain instructions in the matter.
On the ground that, Mr. So-and-so, learned counsel for the petitioner submits that
HR.
on receipt of the affidavit filed by the respondents, he requests, he needs to take instruction from his client. Therefore, praise that matter may be listed after 3 weeks. Praise the Lord.
May
List
please
the
your
matter
lordship
after
with the
3 weeks.
consent of with the consent of the
open
other party.
Instruction.
May please your lordship with the consent of the other party. I would like to present the case number 16 on behalf of M.M. Kotoki, Standing Council of Animal Husbandry and Veterinary Department.
16.
16.
Ah.
She is now out of station because of the sudden demise of her mother-in-law. Her application of leave is already submitted. Lordship
On the
kindly.
ground that MS
M.M. Kotoki.
MM Kotoki, learned counsel, learned standing counsel for AH&V department, having in bereavement, MS so learned counsel for the petitioner is on his behalf for adjournment of the matter to
Kindly
3
fix
weeks.
the matter of 3 weeks.
Kindly fix it.
Whereas allowed list up to 3 weeks.
Kindly fix date. Kindly get it fixed. Pension matter, my lord. The pension matter.
Give.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 21, my lordship. Hello, the conducting counsel, Mr. B. Pathak is out of station on maternity.
On the ground that Mr. Conducting order, Mr. B. Pathak, learned counsel for the petitioner is out of the station, Mr. So-and-so, learned counsel for the petitioner, press for adjournment of the matter. Prayer allowed list the matter after 4 weeks. 4 weeks.
2 weeks, madam. I beg to mention item number 17, my lord. Yeah, well, affidavit is given, but we not responded. So one accommodation may be given. With consent of the other parties.
You are for
I am from the petitioner, so we want to respond this.
Mr.
M.J.
M.J. Barua, learned counsel for the petitioner, press for and is granted 3 weeks time to file affidavit.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 28, lordship. They have the respondents have filed their affidavit. We would like to file a reply.
MS so-and-so, learned counsel for the petitioner, press for and is granted 3 weeks time to file affidavit in reply. List after 3 weeks.
Lordship, I have a similar prayer for item 34, lordship.
24.
Lordship,
Yes,
they have
same
not
order.
filed their affidavit, lordship.
54.
34, lordship. The respondents have not filed their affidavit, lordship. Respondents have not filed their affidavit, lordship.
You said similar prayer.
Lordship.
Can you force them to file affidavit? Is that right? On the prayer of MS so-and-so, learned counsel for the petitioner, list this matter after 4 weeks. In the meantime, respondents may file their affidavit.
Much obliged.
Lordship, timing, Lordship. As does is appearing, Lordship.
Huh?
As does is appearing in this case, Lordship.
So,
He's coming, Lordship. Timing, Lordship.
Lordship, I apologize, lordship. In item 34, there is an interim prayer. Highly obliged.
Punishment was imposed in a departmental proceeding.
yes.
Stoppage of the, but the reply has not come, my lord.
Yes. Which court state? Which for the state?
Advocate.
Police Department, DGP, Chief Secretary, IGP, SP. Where the government lawyers are? Huh? No government lawyers. Arbiter, so it's then consent for the non-appears for the state respondents. Despite availability of battery of lawyers appointed by the state government, list of the state has failed to file affidavit since 2020. This matter after 3 weeks. On the next day, the London Government Council may to produce their records.
Well, date may be given since they have not appeared, my lord. Date may be given, my lord.
That's right. By way of an opportunity to the Government Council. The matter, let the matter be listed after 3 weeks, huh? On the next day of listing, the London Council, the London State Council to produce records.
My London Council is out of the station due
Ah,
to ill health. Therefore, can get on the matter.
what is the matter?
Lordship, regulation of service, Lordship.
Huh?
Regulation of service, Lordship. They are claiming for regulation, your Lordship.
So,
But Lordship,
have you filed the affidavit?
no, Lordship,
Why?
updated instruction is not received, your Lordship.
It's 2022,
Lordship,
last
but
opportunity.
but Lordship,
Mr. So-and-so, London Council for the Petitioner. MS,
J. Bora, Lordship.
London State Council is granted
Lordship, PNRD Department.
granted
Lordship.
4 weeks time to file affidavit as a last sentence. This after 4 weeks.
My lord,
Yes,
they have submitted the affidavit in opposition, my lord. I may be allowed to submit reply.
on the Mr.
A.M. Bolvi.
A.M. Burgoy, London Council for the Petitioner. Press that he may be granted 3 weeks time to file affidavit in reply. Prayer is list after 3 weeks.
All the respondents,
Mr. A.K. Datta, for all the respondents, is present.
Earlier interim
London
order.
Council.
Earlier
Interim
interim-
order pass earlier shall continue.
Obliged.
Yes.
Very limited plan. Here, but the petitioner is seeking appointment in a grade 4 post pursuant to the rule 4(1) of the Assam Public Service Preferential Appointment Rules, which is meant for the persons who are family members of victims of Assam movement.
Yeah.
And these rules have been framed for those persons who are victims for the Assam movement on foreigners issue, my lord. And as per the rule 4(1) of this Assam Public Service Preferential Appointment Rules, this person's family members, when there is no other service holder in the family, then they should be given preference, my lord, in the matter of appointment. And so he has applied for appointment in grade 4 post. the agriculture department as well as civil service, civil supplies department, but till now they have not considered. So there are instances where this honorable court has given directions to the concerned authorities or departments to consider the case of those who have applied in terms of these rules, my lord. And that similar order I also annexed, this is a page, in page 20, annexure 8, my lord. Annexure 8, the last, in terms of that also. Page 25, page 25.
Page 25.
That will make clear what is regarding the appointment of the property. Consider their case when they applies for it. And last time,
Have you applied?
yes, I have applied, Madam, and even the instruction was sought from the petitioner whether he has applied, and I have got his admit card of this that he has applied to apply.
So what is their stance?
Lordship, we filed the affidavit, Lordship, here in this case, Lordship, respondent 7 filed the affidavit. Lordship, here in this case, Lordship, so far, this is the preferential, Lordship. That is the policy of preferential, Lordship. If two candidates appears in the same numbers, then the preference will come to the petitioner.
That's also
That is the rule, Lordship.
He applies for any post wherever he's applied, man. No.
Have you applied for any job?
Yes, but I have, even last time, instruction was sought from a petitioner that here I brought the admit cards, that is.
No, I applied for, in the sense, suppose if you apply for a job and in the interview after the selection process,
Yes, ma'am.
in that case, only preference will be given.
Yes, Lord. Yes, that is the
It's
rule.
not that you apply for a job and you will be given preference.
So he is applied, but that admit card I have also, last time instruction was sought in this regard. Man.
Which post?
For any grade 4 post, man, department of any grade
No,
4
not any grade. This has to be certain
Yes.
selection process has to be there.
that he will go through. That will definitely have to go through that process.
Then you come back after
Yes.
thereafter.
But he is already applied, man.
Which one?
For any grade 4 post in the.
No, it cannot be any grade 4 post.
There should have some specific post, Lordship.
Yeah, specific post, specific selection
Yes,
process.
Lordship.
But this is for grade 4 post, the state level recruitment commission.
Where is that?
Okay.
Where is that policy?
But that's
Page
the rules, man.
rules. This is a rules or what?
Yes, for rules. The rules have been framed in this regard.
Okay, 1919. Assam Accord. What is this?
That Lordship has got it, but I can provide it, madam. The rules are here. Assam service manual.
No, what
Service
the rules is called?
Page 1.
What is the name of the rule?
Lordship,
Page 1. The Assam Public Service Preferential Appointment Rules, 1999.
rule 4.1, 4.2, and 4.3, Lordship. 4.4
I think we have got
of
it.
the rule.
Assam Rule Public Services Preferential Appointment Rules, 1919. Yes, rule.
4.1. 4.1.
Subject to the provisions of this rule, wherever any recruitment to the service and post referred to rule is made, one affected candidate who is otherwise. Wherever any recruitment to services and post is made, one affected candidate who is otherwise eligible under the normal rules. Citizens will be given preference in making appointments. Yes, sir. Until unless you applied and
So
you
he has applied, madam. Even the admit card only issued, madam, to him, but
which post?
it actually for gets 4 posts and it is conducted by the state level
Which
recruitment commission.
department?
State level recruitment commission for class 4 post, madam. That is the commission, madam, who conducts this proposed examination for selection.
The commission is not the party here, Lordship.
None is got part of a party, but
It is not,
But the
the commission
department
is not the party. Where he applied, the commission is not the party here, Lordship.
But the department I made.
Department,
Yeah,
it is a
department.
general recruitment, Lordship. It is through the commission, Lordship. The commission is not before this, before your Lordship, Lordship.
Which commission?
Yes, Lordship, the state level recruitment commission board for grade 3 and grade 4.
Get for class 4 post.
They have issued an advertisement.
Lordship, already issued, selection was made, Lordship. Already selection, selection was made, Lordship. Now it is for verification is going on, Lordship.
So that I limited player only for his case to be considered
No,
a kind of selection.
But whether he got the selection, after selection, Lordship, if two persons
yes.
are appeared, just a minute. If two persons were, if person are appeared in the same category, same number, then yes.
He's not selected.
Yes.
There.
Yes,
But
Lordship,
in case of-
preferential will
In
come.
No, in case of selection,
Yes,
the rule has to be, will tell you to.
That will be compliant, my lord. That is my prayer, my only. That is only this
No,
direction,
no, but
direction.
the
That needs to
commission,
be compliant.
no, commission is not before this, before your Lordship.
It's under the department only.
No, that is not under any department, Lordship.
Where
It
is the advertisement?
Advertisement, I have not taken expert, I don't know, but he has applied, my lord, that is all stated, my lord.
On what basis?
Application is on page 18, my lord.
Huh?
Advertisement, I am not here. It is not here, madam. At page 18, I am only a.
You have applied to Chief Minister.
Prayer, my lord.
Food and civil service, respect the son of services and the victim must be applied. Chief Secretary for appointment in vacant post in food and service, but no action has taken. Where is that advertisement? I mean, the selection notice, whatever.
That advertisement, I have not read that annex.
What is the, you are saying, talking about admit card, where it is?
Admit card is there. Admit card is, I have. So, not annex, my lord, I have got it later on subsequent.
Let us see. Nothing is on record whether about the selection process. Have
Yes,
you pleaded?
No, but that's.
Have you made an averment in the writ petition?
No, Lordship.
Regarding advertisement.
No, Lordship. No averment is there, Lord. Regarding
Whenever-
this
whenever-
election.
Recruitment Commission.
Whenever there is any process, my lord, that is the direction we.
No, it should not be a blanket direction.
No, direct,
It should be the specific direction.
a similar direction have been issued already by this court, my lord.
No, that is in another sense. It is not the similar case.
This is which year?
22, my lord.
It's still going on.
Now I think.
Already selection list was declared, Lordship.
That I have, results regarding, I have no.
Result already declared, Lordship. It is everyone knows that. The result has already been declared, Lordship.
You said it's under process.
Lordship?
You said under process.
No, this.
While ago you have submitted.
Yes, Lordship, the result was declared. Now, the process for verification of the documents and others are.
You don't know whether you have been selected or not.
Yes, Lordship.
That instruction I have not heard.
Will direct you to consider. I mean, problem
Yes,
is the commission is not again.
Yes, commission is
No,
not.
earlier
not
was
before this.
that commission was
The
not made.
commission is not
Who
before.
is the appointing authority?
It's a commission, Lordship. Commission.
Commission conducts the only selection. Appointment of the authority is the department, my lord.
No department, Lordship. It is a general recruitment, Lordship. For all
Right.
department.
It would not be proper. If the commission selects.
No, commission selects, Lordship. Then,
I'm
Lordship,
asking who is the appointing authority?
Lordship, appointing authority will be the department, but now after before selection, Lordship, selection will conduct by the all selection.
You make a party to the commission.
Yes, Lordship, commission should be the party here.
In that case, earlier was also passed by
No,
the
commission-
court, my lord.
commission-
That's why we have seen the extra 8, my lord. Commission was not made, my lord. Department, since department is the appointing authority. Commission only conducts the exam.
The commission is not able to select the candidate. The department is not able to select the candidates. Only the commission is the authority to select the candidates. Therefore, the commission must before this honorable court.
This is your you have not brought all these things also.
Lordship.
When your affidavit, nothing is there.
No, in my affidavit, it says the rules are, we submitted the rules. What is the rules? But at the same time, he is not categorized us, Lordship. Because he is not, he
You are
is not,
for what?
I am on behalf of the department, Lordship. The he has not applied and for any post before the department, Lordship. He applied, according to him, at this stage, at this stage of hearing, he stated that he was applied in the post which is announced by the commission, Lordship. Commission, but commission is not before this honorable court. These admit card that
No, you have filed this writ petition after this.
No.
After filing a
Before
writ.
this.
Huh?
This was like subsequently, but.
Then you should have filed a appropriate.
Yes, Lordship.
Because
See,
at
direction
the time of
cannot be
selection, this case be considered. That was on immediate prayer only.
Huh?
Only at the time of selection, this case be considered as per the rules. This rules can be complied with.
Commission is not before this court. How can we directly
Yes, Lordship.
consider?
Lordship is true.
Then I will make the party will necessary commission as well. Let me some time given, I will make the.
No, and at the same time, you have not said anything about in your petition. You have not pleaded anything about this election.
Yes, Lordship. Not
Yes,
Because
you
I have said it, but only the.
No. Your page 18, you have approached the chief minister, saying that you have approached the chief secretary for appointment in the vacant post. That cannot be allowed. The preference under the rules is pertains to any on selection, any selection process. Sir, it appears that you have not done your homework.
But that was only about the application I have one.
That you cannot. That on the
Any appointment that any selection that is done.
It cannot
there
be
is
the
always
blanket
there.
order.
Then can consider as per the rules, man. That is the limit.
Sir, this
That is
always
I am
there.
fall in this category, man.
It's always there. When the rules and acts are already framed by the state, they are bound to comply. If they don't comply in a specific cases, then only we will consider, will determine.
No, earlier he has applied, man. That was not. That is
Where
why he
your
has-
application?
That-
Your application is to the chief
Chief
minister,
Minister.
saying that I have applied to the chief secretary for appointment. Where with you, we would like to give you a relief, but then there's nothing in the pleading. At least even if the commission is there, you could have pleaded a specific selection process. That I have applied, I have.
No, initially he applied directly to the departments, I think, and all that. But subsequently, this post where examination was supposed to conducted by the commission.
That's the thing.
Right.
Subsequently, if there is any subsequent development, it's your duty to bring in the court.
That's why last time instruction was sought for that regarding whether it is applied or applied for that. Admitted.
Where it is, by which order?
I think that order 26/10/22, it is there, man.
26?
10/22, man.
Yes.
Lordship, my instruction is no, Lordship. He has not applied for any post before the department, Lordship, because the department is not conducting the process, Lordship. It is the whole process has conducted by the commission, Lordship. Recruitment board, Lordship. And whenever the department, whenever any vacancy.
Hazarika. You are Hazarika.
Yes, ma'am.
You are the one who has prayed for time to
Yes.
obtain instruction.
That's why that
As
advocate,
to whether the petitioner has taken part in the said recruitment
that
process.
advocate, that is why that advocate.
That is in the subsequent to this writ petition,
after
filing
that-
the writ petition, and therefore the commission must be before this honorable court, The recruitment board must be there.
No, we'll.
Any order that can be passed in terms of annexure 8 manner, that's the only limited prayer I am seeking, my lord. In terms of annexure 8 manner, no limited prayer that is fine.
What is annexure?
That annexure 8 that earlier this court has passed order
No,
in the
it
respect of
cannot be on a blank
similar
check.
situated persons, my lord.
Selection,
Similarly situated persons, but in
the result was declared, Lord.
Oh. So
And
that-
how can
that's
this direction will effect?
the last part, my lord, page 26, para 9. Para 9 of the last. Similarly situated persons have been applied like this earlier, and they have also approached these honorable courts, and they have been given their relief in this manner, my lord. Last step. Every time this selection manner process, then everything cannot come to the court, my lord. Only that rules may be complied, my lord. That's not, my lord, in any respect.
In no case order. What would be the problem?
No, this.
What would be your problem?
Here in this.
Rule is still in force.
No, Lordship. This order, circumstances of this order is not similar to the petitioner's case. Because
He is not asking for that. He is not asking a specific appointment now.
Look,
he's now. The council is not asking for any specific, as and when there is a selection process, if he participates.
No, selection.
The rule has to be.
Already,
That will
no,
comply, but that's
Lordship,
not so.
already selection process was over. The written result for the written examination was declared. Now, for verification, calling was issued, Lordship, by the board. First, he have to ascertain whether he was success in the examination.
IA has declared learned counsel for the petitioner and Mr.
J.K. Goswami.
Learned discerning counsel.
Additional senior government advocate.
Additional senior government advocate. For the state, you have to.
Lordship.
For the state. Next para. By filing this writ petition, the petitioner has prayed for a direction to the respondent authorities for appointment of the for appointment in any suitable post. Commensurate with his qualification by giving preference in terms of the, though your prayer is not, there is nothing on the prayer.
Yes, Lord.
In terms of the ASHA public services within bracket, preferential appointment within bracket rules 1991.
Education already as one
The next para, huh? The petitioner claims to be the petitioner is an educated, unemployed youth, belongs to OBC class, and has passed the higher secondary school certificate in the year 2008. And also diploma, having the diploma in computer application. Mr. He belongs to a category of an affected family, being next of kin of person with the next of kin of person whose father led Purananda Saitya has become permanently disabled due to participation in the ASHA movement. ASHA movement of which year? Year it is ASHA movement, Mr. Next paragraph. It is the contention of the petitioner that as per the Assam Public Services within bracket preferential appointment bracket rules 1999. He is entitled to be appointed in any suitable vacant post in commensurate with his qualification. Mr. Having the eligible qualifications, the petitioner has approached the Department of Food and Civil Supplies, Government of Assam.
Lordship, he was not approached before the food and civil supply, Lordship.
Why you are so, anxious?
Yes, Lordship.
I am dictating what he submitted, submitting.
Lordship.
What is that? It's very difficult.
Lordship.
Food and Civil Supply, Government of Assam, for appointment in the category of post reserved for candidates of martyrs and victims' family as per the said rules of 1999. Mr. Having, on being not considered, he approached the Honorable Chief Minister of the state on 27/01/2022, seeking his intervention for the grievance which he has raised before the department, in other departments, in the department, in the state department as well as other departments in the state. Mr. IA Hazirika, learned counsel for the petitioner, submits that although the petitioner has approached the Department of Food and Civil Supplies and thereafter to the Honorable Chief Minister, he in fact applied for appointment pursuant to the notice, pursuant to the advertisement issued by the State Levels Recruitment Commission for Class 4 post, for which he has been issued an admit card. List of admit card for recruitment of Class 4 post under the government of ASHA. List of although, please, he submits that although he doesn't have any instruction as to whether the petitioner has been selected, whether the petitioner has qualified in the said recruitment process conducted by the State Level Recruitment Commission, the respondent authorities, including the State Level Recruitment Commission, are duty bound to adhere to the rules, adhere to the to the Assam Public Service, the provisions of the Assam Public Services within bracket preferential appointments so and so rules, 1999. Agricultural Department of the Potential Senior Order. Agriculture. Mr. Therefore, he submits that a direction may be issued to the respondent authorities to appoint the petitioner by adhering to the provisions of the Assam Public Service Preferential Rules 1999. Next paragraph. What is your submission?
Yes, Lord. First of all,
J.K. Goswami, learned counsel for the learned additional senior government advocate.
Lordship, first,
Submits that.
yes, first Lordship, the board is not the party here.
Submits that.
The State Recruitment Board for
Submits that
grade 3 and grade 4.
in view of the non-gender of the commission as being a necessary party, the writ petition is not maintainable.
At the same time, Lordship, the in his petition, Lordship, in his petition, the subsequent development regarding the application made by him before the board selection process conducted by the State Recruitment Board is not in the averments of the petition, Lordship, writ petition.
At the same time, there is no pleadings in the writ petition as regards the recruitment process conducted by the State Level Recruitment Commission. Listener. He submits that the provisions of Assam Public Service Preferential Appointment Rules 1999 shall be would be applicable in case a candidate in any recruitment to the post recruitment to the post, is qualified as the same provides for giving preference in making appointments. Mr.
Next,
Until the candidates qualified, there's no question of giving preference.
yes,
In terms of the rules. Mr. Therefore, apart from semester, apart from non-maintain, no, the petition being not maintainable for non-gender of necessary parties come up. Equally, the on merits to same cannot be.
Lordship.
Same
The
is liable to be infected.
read, yes, the read petition which is the order dated 3/4/2019.
Going into all that,
Yes, in this read petition is not similar to the present case, Lords.
it's okay, we're not also relying on.
Same, yes, yes.
We're also not relying on it. Next, I have considered the submissions of learned counsel for the parties and also where is the materials placed during the course of hearing as well as the relevant provision, as well as the ASHA Public Service Surrender Rules 1999, right? Next paragraph. Admittedly, the petitioner is the son of is a it belongs to a category of an affected family being next kin of a person which as his father has permanently become disabled due to the participation in the assembly. As per the provisions, please stop. The next paragraph. Considering that considering the grievance raised by the petitioner, essentially to the effect that the petitioner be appointed by giving preference, be appointed essentially for a direction to the respondent authorities for appointment in any any suitable post commensurate with his qualification by giving preference in terms of the Assam Public Service Preferential Appointment Rules 1999. Come on. I deem it opposite APT or SIT to refer to the said rules 1999. Mr. Next one. It is noticed that the Assam Public Preferential Appointment Rules 1990 is a rule made under provision to Article 309 of the Constitution of India. For which regulates the appointment in public services under the government of Assam of the next of kin of the person who sacrificed their lives or who have rendered physically disabled permanently by bullet injury or otherwise while participating in the ASHA movement on the problem of foreigners. Mr. Rule 2 within bracket cross defines the affected candidates. Means a candidate who is a member of the family of a martyr or a member of the family of a person who has been rendered physically disabled and possesses a certificate to that effect issued by the Deputy Commissioner of the respective district in such form as may be. Definition of the respective district, page 127, definition, page 7 of this book. You just see there any confusion. I'm just next paragraph. Rule 3 provides that the rules shall apply to all the services and posts under the government of Assam, recruitment to which are made through the Assam Public Service Commission or otherwise then through the Assam Public Service Commission. Rule 4 provides that wherever any recruitment to services and posts referred to in Rule 3 is made, one affected candidate who is otherwise eligible under the normal rules shall, ceteris paribus, be given preference in making appointments, with a proviso that such preference shall be subject to the reservation in favor of candidates who are members of the scheduled tribes, plain and hills, within bracket, other backward classes, etc. Now, other backward classes, including more other backward classes, ex-servition and physically handicapped persons. It also further provides that appointment of any affected candidates who is also a candidate of the category mentioned in the preceding proviso shall be set up against the percentage reserved for the members of that particular category. Look at next page. On where perusal of this other provisions reflects that, shows that, no, not that, shows that the state has framed the rules which appears to be which the no state has no rule shows the beneficial no so shows that the next of the kin of the persons who sacrifice their lives or who have rendered physically disabled permanently by bullet injury or otherwise while participating in the Assam movement on the problem of foreigners is to be given preference while preference in the recruitment process for appointment to any post or services under the government of Assam. The rules appears to be a piece of beneficial legislation. Mr. Next paragraph. As noted above, there is no dispute that the petitioner is the next of the kin of the persons who have physically who has rendered physically disabled permanently, and his father has been rendered physically disabled permanently, for which the competent authority has issued a certificate to that effect. Huh? Mr. The rules, the provisions of the rules of 1999 so far as the applicability of the rules is concerned, there's no dispute for such applicability for recruitment of services under the government of ASHA. Next panel. In the present case, what has to be determined as to whether the petitioner is entitled to a preferential treatment for appointment in terms of the said rules, in terms of the opposite rules of 1999. The learned counsel for the petitioner. No, Mr. During at the time of hearing, the learned counsel for the petitioner has placed a copy of the admit card of the petitioner issued by the state level recruitment commission for recruitment of class 4 post under the government of ASHA to project that the petitioner has participated in the recruitment process in the year 2022. However, the learned counsel could not show that any documents or any instruction for that matter indicating whether the petitioner has qualified in the selection process. It is true that the provisions of the rules, particularly Rule 4, would be applicable in case of recruitment to the post or services under the Assam, under the government of Assam, provided the candidates qualified in such a recruitment process. There would not be any blanket application of the rules. And the appointment cannot be made on appointment cannot be made on any services by just providing a preference, would there be any selection process, selection or recruitment process? Having considered the above, come on, I'm of the view that no specific direction can be given to the responding authorities to appoint the petitioner in terms of the provisions of rules so 1999 as it run counter to the intent and purpose of the rule making, intent and purpose of the rules and the rule making authority. However, since the rule is undisputably still involved, the responding authorities are obligated to adhere to the rules while the process for selection of the recruitment of to any post or services are being taken up. Next, as noted above, there is no clarity as to whether the petitioner has qualified pursuant to the admit card issued to him by the state level recruitment commission for recruitment of class 4 posts. The relief, this court is constrained to grant any relief to the petitioner in respect of the recruitment, which appears to have already undertaken. Therefore, the relief sought by the petitioner is rejected. However, as the rules is as the rule so and so Assam so and so rules is still involved. It is observed that if the petitioner in any case is qualified to be provided a preference in terms of the above rules, the respondent authorities, including the state election level recruitment commission, shall adhere to the section 44 of the state rules of 1990. It is also further provided that no, not further. It is further observed that the state authorities, including the recruitment commission in the state, would definitely adhere to the provisions of rule So long as it is in existence. In existence and under the existence under the rule books. With the above observation direction, the recognition closed. No.
But time for respondent number 3 and 6.
Yes. What do you want to
Respondent
say?
3 and 6, Arbor
Do you
of
have
Agriculture
anything to say?
Department.
Okay.
Obliged by the order. Arborum. For respondent number 3 and 6. 3 and 6.
On top.
Obliged. Lordship.
Yes.
We take up item number 7 as a lead case. Huh? Item number 7 as a lead case, because in this case, pursuant to your lordship direction, the commissioner and secretary, that is respondent number 1, has submitted and filed an affidavit in the position. And accordingly, I have filed a rejoinder in item number 7.
Yes.
May I pray, Lordship, that matter be fixed on a hearing date, Lordship?
Why? What is the matter?
Matter regarding lordship, I was appointed, my mother was appointed.
Is the way you are walking to appear, walking towards the dice?
Lordship, pardon?
While ago, while you are approaching this side,
Lordship.
you walk like a actor in the movie called Puspa 2. Allu Arjun. So what is the
gist of the case, Lordship?
Yes.
Lordship, my mother was appointed in the irrigation department, Lordship, on 21/5/1991. That is prior to 1/4/1993. And while she was in service, arbitrarily, without issuing any notice, she was terminated by the principal secretary, Karbi Anglong Autonomous Council. And assailing that termination order, my mother and similarly situated person have approached this honorable court by way of filing a civil rule. That is civil rule number 4919 of 1991.
It requires detailed hearing.
Lordship.
Heard, Mr.
GRA
We'll
Murphy.
fix it for hearing. Learned counsel for the petitions. Two petitioners.
Lordship,
Both
petition,
petitioner.
two analogous petition, Lordship.
Different petitioners.
Different petitioners.
Petitioners, huh? It should be same order. 5 and 6. 6 and 7.
6 and 7, Lordship.
Yeah. It is submitted and Mr. So record their name, huh? All of them. It is submitted at the bar that the pleadings in respect of writ petition number
7, Lordship, 2804. WPC
2804
of 2022
are complete. Sorry, pleadings are complete, which would cover the writ petition
1129
of 2022. Having heard the learned counsel with some length command, I'm of the view that the writ petitions would require detailed deliberation. Accordingly, the writ petitions are admitted. Writ petitions are admitted for hearing. List after 4 weeks.
Kindly get that may be given, Lordship. Because the covered case, Lordship, passed by your Lordship in Sujit Kumar Sinha's case.
Huh?
Covered case, Lordship.
Not covered.
Sujit Kumar Sinha, your
No, if it is covered, to 1 page order.
Lordship recently articulated his judgment in Sujit Kumar Sinha's.
We could have argued. Yes, it's not covered.
Lordship.
Please, your Lordship. Lordship, kindly pass over the matter for the time being, Lordship. Matinee is in court number 1, Lordship.
What is the matter?
Lordship, matter pertains to non-appointment
appointment not given to the petitioner, your lordship. Appointment not given to the petitioner despite having court's order.
Why?
But this is the
There is a
matter.
court order, you are not appointing them.
So that's not what the facts are, my lord. Here, what happened, my lord, initially there was an advertisement, but one by SSA and one by the state, where we have debarred the seated candidates, the central TET candidate. The coordinate bench of this honorable court dismissed both the writ petitions. Thereafter, writ appeals were preferred before the division bench. In the writ appeal preferred before the division bench in respect of the advertisement issued by the state elementary education, where this honorable court, the division bench has held that the candidates who have already participated, the writ petitioners and the appellants, for them, it was allowed despite that they have seated without interfering with the advertisement. And there was a direction to fill up the vacancy in two phases. One with the candidates who has Assam TET, and the other second phase who has seated. So thereafter, pursuant to that division bench order, advertisements were issued. Now the subsequent advertisement they have put into challenge, saying that there are no posts for reserved, unreserved category. The breaker vacancy position. But the direction was to fill up the remaining vacancies out of that total vacancies. And by the time, in the division bench order, in the advertisement issued by the state, the SSA has already filled up these vacancies. And so remaining vacancies was advertised. So there is an interim order operating that to proceed with the advertisement and not to, without the leave of the court, not to publish the
appointment of teachers.
Appointment of teachers.
Their allegation is that you have misconstrued the order of this division bench.
That's not correct, Mula. Anyways, Mula, this is
and your counter contention allegation is that they have misconstrued. Rather, they have misconstrued.
Yes. But anyways, Mula, my friend is seeking an accommodation today on behalf of Mr. P. Nayak. P. Nayak. P. Nayak.
Where is P. Nayak?
Mula, he is not. He is indisposed today, Mula. Lordship will take up next week anyway, yes, because this is a matter relates to advertisement of SSA. I am representing the state.
Okay. Not the first thing.
No, they are seeking adjournment.
So, this is why, having opened the brief, making all submissions, now praying for an adjournment.
This court has asked him, what is the...
Yeah, exactly. I asked him, this is already covered this case. There is already decision of a collateral bench.
We'll see.
They have not considered as yet.
We'll see.
And they are buying time only. So
your interim is in your favor.
I'm deeply grateful.
Operating in your
but the time constant lordship knows these are all young boys, young men. They are suffering for last so many years.
We'll decide after 1 week or 2 weeks.
1 week. He's paying for 1 week. Let it be.
Anything as per your lordship. We haven't
heard Mr. K.K. Mohanto, learned senior counsel, assisted by Mr.
S. Gautam,
learned counsel for the police, and Mr. B. Kaushik.
I am for respond number 1, ma'am.
Huh?
I am for respond number 1.
State counsel for respond number. And MS. No, please.
P. Nayak.
MS. Learned counsel.
P. Nayak.
Appearing on behalf of Mr. P. Nayak, learned standing counsel.
SSA.
For SSA. Submits that Mr. Nayak, the council has some personal difficulty for each C6 and accommodation for a period for 2 weeks. We take it after 2 weeks. As consent, as agreed to by learned consent of the parties. No, prayers allowed as agreed to by learned consent of the parties. List this matter after 2 weeks.
Let it be 1 week, my lord. Let it be 1 week.
I think 1 week, sir, it not be possible even if it listed. We have picked so many matters.
It will come
Actually, it is 2 weeks. This code is fixing the matters.
26, 27, if possible, my lord, I think no issue.
Virtually, this last 2 weeks, this code is fixing the matters after 2 weeks, 3 weeks. So I don't want to.
My lord, I would not have objected had this been a case which could be could have been waited.
After 10 days, you just
Yeah, Yes.
Grateful.
In between 2 weeks and 1 week. Yes.
All right.
Last April, I think we have also fixed so many meetings. Yes.
The matter relates to recovery of excess payment made by the department.
Already recovered?
Not recovered, my lord. When the
You
excess
want to,
payment.
recover?
Yes, my lord. There was some.
No, when the existing rule, at that point of time, there was an existing rule. Is it a rule?
No, my lord.
Existing rules provides, the provisions of existing rules made her entitled. Accordingly, she was paid. Thereafter, there is a
Wrong
change in the rules, I think.
Wrong calculation. We have excess payment, which is detected by the CSG during audit. My lord, some similarity situated person have been paying, refunding the money, and some are approaching this honorable court. And 8 cases of similar situated person is disposed of in the light of Rafiq Masi case, my lord. Treating the post of staff nurse as a grade 3 post. But in fact, the central government categorizes employees on the basis of the pay scale, grade pay, the level, now level.
No, whether this has been disposed of.
Now,
Similar matter has been disposed of.
my lord, disposed of, my lord, it is now the writ petition is pending before this. Writ appeal is pending before.
Appeal is pending.
I beg to submit that some petition has been disposed of. They have challenged this in the review again. In review, after long hearing, it was upheld.
Dismissed, review was dismissed.
Review was in the review.
Now it is pending before the.
Now they have again preferred an appeal.
Review
But not against this case, madam.
No,
Not against this
cannot
case.
be. This
Yes.
has been, that will cover.
Yes.
Review court observed that at the time of dismissing that in review, the review cannot take the character of partake the character of an appeal.
It's okay. We'll not go into that. That is the law.
Yes.
That is the law.
That is why we preferred appeal, my lord, and admitted also.
Is there any stay?
No stay, no stay.
Admitted, my lord.
No stay, it has been fixed for in due course.
No, now what is to be done?
My lord, the
interim is direct that the recovery is, no, there is an interim.
We have got interim, my lord. We have got it not to
Yes.
recover, not to recover.
Not
But
to recover.
concerning the
Therefore,
delay.
we'll list the matter after disposal of the writ appeal. That will be better. Or Mr. S.P. Biswas, learned counsel for the petitioner. Mr. A.K. Dato, learned counsel, learned CGC.
No.
Learned CGC.
Standing council of
Learned
CGC and
counsel.
standing.
Huh?
Of
CGC
Regional Institute
and
of Mental Health,
mental health.
Tejpur, Regional Institute of Mental Health.
Learned standing counsel for
Tejpur and CGC also, my lord.
in which behalf you are appearing. And on
1 to 3, my lord. 1 to 3, 1 is the union. And 3 are the institute. 2, 3 is the institute.
For all the respondents. Learned counsel.
Except for my lord.
Learned standing counsel as well as and the CGC. Right? For respondents. Submits that the analogous matter arisen out of same orders. Same orders.
Yes.
Is pending before the pending consideration by the division bench.
Yes.
Therefore, praise for listing of the matter after 4 weeks. having considered that the similar matter pending consideration by division bench, list this matter after the disposal of the writ appeals.
Yes.
Give the number. You have
My
the
lord,
number.
we have filed 8 numbers against the writ appeal number, writ appeal number 50.
Lead appeals. Leading case being leading appeal being
WA number 50 of 2025
25
and 51 of 2025 and 52.
50 of
But are they interim order shall continue?
interim order passed earlier shall continue.
May I please your lordship? Here in this case, service of the petitioner was dismissed by the disciplinary authority due to case was pending against the petitioner minor. Minor original appointment of the petitioner is set aside by the honorable court in a separate proceeding on the ground of qualification to minor, which has been silenced before the division bench by writ appeal number 213/24. Appeal is admitted and fixed for hearing. Minor finally adjourned this matter.
Out of similar, how can it be similar?
Minor separate proceeding minor.
Separate
Original
proceeding?
appointment was silenced minor, set aside by the honorable court. Original appointment was set aside by the honorable court minor. Minor, which is silenced before this division bench minor, which is pending.
Original appointment?
Yes, minor.
Appointment of the petitioner was challenged and that was set aside, lordship. And therefore the petitioner before the divisional bench, lordship.
So what is called?
This is the departmental proceeding, lordship. Subsequent department. Now, her appointment was challenged. And
so once the appointment goes.
Yes, goes. Now the appointment goes.
Remains.
Yes.
No proceedings.
No, now it is under this is against the departmental proceeding, lordship. But earlier appointment
No,
was goes.
according to if the appointment goes,
yes,
there could not have been any proceeding.
Yes,
there would not be any proceeding.
Lords.
Further proceeding. Lords. MS Learned Counsel for the petition and Mr. J.K. Goswami, Learned Counsel for Learned Additional Senior Government and Wait for this state. Next paragraph. It is submitted at the appointment of the petitioner has been set aside by by this court, for which an appeal
Pending.
against which
Writ appeal number 213/24.
matter was taken to appeal, which is pending, being WA
213/24.
2024, which is pending. Therefore, no, Mr. Considering the submissions, in view of the above, since the challenge made in this petition is to the departmental proceedings, and as agreed to by the Learned Counsel for the court, this matter after disposal of the writ appeal being 213 of 2023. Okay.
One of the issue is very simple matter. The Honorable High Court, while exhibit J page number 45, directed us to file review within 4 weeks, my lord. Your lordship may see page 45, my lord. Page 45, my lord.
Yes.
Your lordship may say last part of the order.
Yes.
Para 12, page 50. The operative portion of the order, my lord. It is seen that the order dated 3/12/2014 passed in this petition. This court had directed the status quo existing as on date in respect of appointment of Gambura on the budget. Borghat Plat Kismet shall be maintained. It is submitted that on the strength of the said interim order, the petitioner is continuing and served as the Gambura. Hence, it is provided that a period of 4 weeks from now till such review is filed, the status quo order in respect of appointment of the petition shall continue. Thereafter, the review authority shall have discretion to pass not to pass any interim order and as it may deem fit and proper. So 4 weeks time was granted, my lord. I have handed over my papers and everything to the council there, my lord, at Tejpur, but he did not file it, my lord. Then there is a delay of 2.5 years. Lordship may say the page 52, I made a complaint to the bar council about not taking steps to file review. And finally, I filed my review, my lord, which is at page 55. And thereafter, that order, my lord, passed on my lordship may see that order is at page 67, my lord.
What is this?
But my review has been dismissed on the ground of.
Hence, it is provided for a period of 4 weeks from now.
Yes.
In such review, which review?
Review means under the executive instruction, my lord, I have to file a review, my lord, within 4 weeks, which page 55 is the review, my lord, that I filed the review. Lordship may say, same, see, my lord, page 55. Before the commissioner, my lord, a review petition filed under clause 162D of the executive instructions under Assam Land Review Regulation. So, my lord, this review, there is a delay, my lord, and without issuing notice, the review has been dismissed on the ground of delay, my lord. My only prayer is that, my lord, he is continuing as the Gambura, let him continue. And I have actually, my forefather, all were Gamburas, my lord. And it was not accepted because the place of residence, my lord. But the Honorable Single Judge has passed the order. Lordship may say the one observation which is covering my case, my lord. Page, my lord, 49 may be seen, my lord. Para 8, it is thus seen that the page 49, para 9, my lord. My Gambura has not been accepted because my place of residence is different, my lord. Para 8 may be seen, my lord. It is thus seen that the place of residence of the candidate, page 49, my lord. Para 8. It is thus seen that the place of residence of the candidate for appointment of the post of Gambura is not a factor provided for in the executive. So, the place of residence is not a factor, my lord. In 2013, I was appointed as a Gambura. And I was serial number this. Now, lordship, the imping order, lordship will see.
No, what do you want in this petition?
Page 67, my lord. I'm only thinking, my lord, my review should be heard on merit, my lord. It should not be dismissed on. Let him continue, my lord. I have no objection to that. But I have worked for 10 years, my lord. Thereafter, 2023, I was removed from the Gambura.
Is it not delay?
There is a delay, my lord, but delay because of, my lord, I've given the file brief, everything to file review to a lawyer at Tejpur. He did not file it, my lord. And I was, then the COVID was there, my lord. So when I went there, then I found that nothing has here.
It's the fault of the lawyer.
Lawyer, my lord. That I have made a complaint, my lord.
Yes, here it again dismissed.
Page 67 and 68 is the imping order.
Who has to hear?
The commissioner, my lord.
We have filed our affidavit.
Huh?
We have filed our affidavit, Lordship.
Saying what?
Saying that there is a huge delay.
No, you considered everything. I'm not heard.
I'm not saying that, my lord.
Have you been heard?
Heard, my lord. That should be heard. My review should be heard.
No, have you been heard?
No. It has been dismissed.
For passing this, the impugn order.
Lordship, see page 67 is the impugn order, my lord. Page 67.
67.
68 is the final order, my lord, operative portion of the order. Lordship, see the top portion, my lord. 67 and then 68, my lord. Where is the honorable? Whereas the Honorable High Court wide order dated 15/7/2019 allowed the petitioner to file review within 4 weeks. However, the petitioner failed to submit the review petition on due time. Whereas views of Judicial Department has been obtained, Judicial Department is of the view the interim order dated 15/10/2014 of the Commissioner NAD Tejpur was set aside by the Honorable High Court by order dated 15/7/2019 passed in WPC number so and so, allowing the petitioner to file review within 4 weeks from the said order. Clause 162D of Executive Instructions of ALR 86 provides that for 90 days time for review, which was extended by Honorable High Court by another 4 weeks time from the date of order dated 15/7/2019 passed in WPC number so and so, and being so, the said time lapse of after 4 weeks 15/7/2019 is about 2.5 years since then. The ground of delay is established through allegation, though allegation is made against the advocate concerned. In view of the above, appears no ground for condoning the delay of preferring the review matter.
As per Executive Instruction 162D, they have to prefer appeal within 90 days. That has been extended by the Honorable Court after again for 4 weeks. That means 1 month.
It's a fault of the lawyer.
But that has not been established. Some allegation has been
You
made
have
by the
not been
petitioner.
allowed to establish. You have not allowed them to establish. Show them now.
That has to be decided by another authority.
And then more so, you have decided on the
Otherwise,
basis of,
since there is a
that apart, you have decided on the basis advice of the law department.
that has Judicial Department
authority.
before passing this order, Judicial Department view has already been taken.
When the appeal and review is filed, you act as a judicial authority.
From the first order, another order was also passed.
Anyway, we're not going to it. We hear it and you dismiss the petition again.
Let me dismiss my review, my lord.
To that effect, that for limitation, I want to place on judgment because since there is a statutory period is prescribed, that has to be followed by the.
So you will have to assail the last order where the four which was
that has been extended. There's another litigation also. Due diligence.
Yes, who is for respondent, private respondent?
Yes, my lord. I am appearing for respondent 8, my lord.
That's private respondent.
Here, my lord.
Appears to be the petitioner has not been heard.
Yes,
and the delay was due to the lawyer's fault.
Your lordship may kindly come to page 70.
Page 69.
Page 69, yes.
Will not comment on the merits?
Yes, cannot, my lord.
Honorable Court, my lord. After hearing all the parties and perusing all records, my lord, this order was passed.
Which one?
On, my lord, page 70, my lord, relevant for page 70. Page 70, my lord.
Huh?
Page 70.
I am respondent number 4, my lord. I have not been heard by my lord. None appears for respondent number 4, my lord.
What is this?
This is an order, my lord, reinstating him as a Gampura, my lord, because there was an advertisement. So Gampura post has been filled up. He was the candidate. He has been considered. So my question is that, but I'm not on that. I'm on that review should be heard and should be decided, my lord.
Basic facts of the case, my lord. Advertisement was issued, my lord, based on locality, my lord. Application was sought from locality, my lord, local candidate, my lord. He is not outside, he is an outsider. Although he applied, he is an outsider, my lord. Thereafter, my complaint was raised. Specific report was given by the circle officer that he is an outsider. Even then, my lord, appointment was given to him. That was challenged under Executive Instruction 162C before the North Assam Division Commissioner, my lord. Commissioner set aside his appointment and directed to appoint the petitioner within time frame, my lord. Thereafter, he came before this honorable court, my lord. Then, my lord, honorable court directed him to granted him liberty to file and review under Executive Instruction 162D before the government, my lord. within 4 weeks. And status quo granted only with limited to the 4 weeks, my lord. He did not done it. Thereafter, my lord, after 2.5 years, when he did not file anything, then my lord, respondent 8 came before this honorable court, my lord. And honorable court, my lord, call all the records, my lord, from the department as well as record was submitted before this honorable court, my lord. Then honorable court, after perusal of record, my lord, passed this order, my lord, page 70.
Fact remains is that, my lord, whether I am not been heard, my lord, the review have been.
Page 70 order was
granted
passed.
liberty
This is a
to
Supreme
file.
Court's order, my lord. Two judicial order is there. No one is challenged by that, my lord, petitioner, my lord. Till date. And subsequently pursuant that order, appointment has been given. Accordingly, my lord, petitioner is respondent 8 is serving, my lord. Even then, appointment order has not also been challenged, my lord. The judicial two orders, two single judicial orders, they have not been challenged. They have not challenged it. And
Yes, this is later point of time. That review directed to file review was on in the year 2019.
Yes, my lord.
This is 2022. And
Because
that
COVID and other
the
things,
court
my
has accepted that the review has not been filed till that time when this
Right.
order.
I'm not saying that, my lord, because I've given to a lawyer, my lord, who was not that. Therefore, I made a complaint,
No,
which
it's
you should
okay.
see at page 52. I made a complaint against the lawyer, my lord, at page 52. I mentioned everything, my lord. Lordship may say
No,
the
no,
respective-
see, is no review has been filed by the respondent till then against the others passed by the commissioner. The order that is passed in appeal would have to be given. According to the respondent direct to issue appointment in favor of the petitioner as governor of the so and so. In terms of the order that is passed in appeal so and so, so and so. No, that has been upheld. What review? Suppose if the review is in.
But
Take a
review-
sit over this.
Lordship, the appeal order at page 67 and 68. It says that, my lord, my review, because
Sir, it
the
would be a
court has directed.
it would be a mere formality. Suppose if your review is not dismissed on ground, on merit also this can be dismissed.
No,
Because
that's
the
correct.
appointment,
I'm
no,
not on that.
ultimately review is what?
My lord, I'm not on the merit of the case. If my review may be dismissed. That's all. Only thing is, my lord, that
That
my.
would be a mere formality in view of
No,
this
maybe,
order.
my lord, but my review has to be heard on merit, my lord. That's what I said, because court has, honorable court has.
Sir, see page 70.
Yes.
68.
My lord, first paragraph, I'm reading, my lord. First
70,
paragraph, page 70, my lord. Had Mr. B. Rahman, landed counsel for the petitioner, also had Mr. M.S. B. Bora, my lord, landed counsel for the respondent 2 and 3. May M.S. and my lord, and Bordole landed counsel for respondent 1.
Court has a coordinate bench has taken a view.
Yes.
Taken cognizance. Accepted that as per the records, you have not filed any review. So direction has been given to.
That's what, my lord. Now
ask
my,
and
now-
appoint accordingly.
my lord will see, now my review is there, my lord. I asked my review to be disposed of, that has been dismissed on the ground of delay, my lord. So I'm contending before the court, this court, my lord, that let my review be heard. It may be dismissed, but on merit, it should be decided, my lord.
No,
Because
merit cannot be
on
now.
the ground, my lord, the lordship may see, London single just passed an order that why my Gangura has been rejected because of the place of residence.
We cannot turn it back now.
No, lordship,
Probably you're right, page
lordship
69.
said page 49, my lord. Just come, page 49.
No, we'll not go back to. You come to page 69.
As page 70, my lord.
Lordship, when the
notice was served to you.
Yes,
you
yes,
did
my
not appear.
Yes, yes.
on the last final order, then I
is-
not be served a notice, my lord, because
No,
lordship
it's
will
a-
see.
Not appears
First
to respond.
paragraph.
However, by the order that passed by this court, service of notice said to be complete
Yes.
against the respondent. number
No,
4.
this order,
You
page
have to
70,
challenge everything.
none
You have to
appears.
challenge this also.
Yes,
None.
it does not be challenged.
Non appears for the respondent.
No.
However, by the order that passed by the court, service of notice was said to be complete against the
The
respondent.
respondent 4.
Lordship is reading which page, my lord?
Page
70.
70.
Yes, that none appears for the respondent number 4, my lord.
Ah.
The petitioner case is that the petitioner and the respondent.
No, however.
However, next line. Well, this order has not also been challenged.
However, order dated 37/2000 passed by this court, service of notice was said to be complete against respondent number 4. Right, my lord, the petition.
So
Lordship may
once
see-
it is said to be complete, it is served.
No, Lordship, Lordship may see my complaint, my lord, which has made to the page 50.
No, no, that is
No, Lordship may say page 52, my
So
lord.
how do we overturn this judgment?
Lordship may say page 52, my lord. For a moment, my lord, page 52. Page 52, Lordship may see.
Yes, professional
With
misconduct.
reference to the above subject matter, it is stated that I have engaged the learned counsel, Mr. Kishore Kumar Bodole, Teshpur Bar Association, to file the review application against the order dated 15/10/2014, passed in case number 2 of 2014 by Commissioner North Assam Division, Teshpur, in view of the order dated 15/11/2019.
No, no, in that case, I understand. I understand.
Accordingly,
You file a review in that case.
That's what that review is filed, my lord.
4542.
But Lordship may see my prayer in that writ, my lord.
4542, you have said the review petition and not representing new writ petition so and so, which ultimately dispose of without any representation. You first overcome this.
Lordship may see my prayer in that writ, my lord. Present writ, my lord, page 20, my lord.
No, no, I've seen it, but sir, problem is this 20/09/2022. Your complaint is in not only filing of review against non-representation in the writ petition. That is a good ground for review until unless this order is modified. Cannot be.
That's what my
Because
lord.
ultimately, what is
No,
the matter?
that's why in the writ.
Appointment of Gaupura only.
Appointment of Gaupura.
On the appeal, the order passed by an appeal, the court has directed to pass an appointment order. Accordingly, order has been passed.
No,
Order has been passed.
No, what I prayed in my.
As per this direction of 12/09/2020, order has been passed. Has the order been passed?
My lord.
Any order, appointment regarding.
Yes, order has been passed. On, my lord,
He is continuing.
serving, my lord, 15/12/2022.
Lordship will see.
You may not be, sir, on that.
No, he is continuing. I am not on that, my lord. Let him continue for another as many as years. But
It's
my
not a
review has to be
question of
heard, my lord.
continuation. Sir, it's a question of allowing him to issue the appointment order in terms of the order passed in the appeal.
Yes.
What has given the stamp?
No.
Because you did not file an appeal.
Now, I did not have review, my lord.
it's a review.
Review.
Now, you have not made a complaint, not only in respect of not filing a review, non-representation in this writ petition also you have alleged.
Right.
That is a good ground until unless this order is modified.
My lord, that is a separate chapter altogether.
No, no.
Why?
That is the
Lordship may single judge. What single judge held, my lord? For a moment, my lord, page 45, Lordship may a single judge. So far, Gambora is concerned, I have been rejected only because of my place of residence. Where single judge, page 45, it held that.
No, you come to page 70.
No, Lordship may see,
And
first of all, how I have been rejected, my lord. Because I have been rejected as a place of residence.
No, sir. How do you overturn this? You may be correct. You may be correct. How do you overturn this?
Lordship will see one.
How can we sit over
Let
this?
me make one submission, my lord. Lordship will see whether Lordship can allow my prayer in the petition, my writ petition. Just for sake, my Lordship may say page 20 is my prayer, my lord. Because I have a judgment, my lord, which can, I'll place two judgment, my lord, in that. It is therefore praised. Lordship may say page 20, my lord. Or the question is this, my lord, whether a judgment of a coordinated bench, whether Lordship has the power to review or not. It is therefore prayed that your Lordship would be pleased to admit this application, call for the records and issue rule upon the respondents to show cause as to why a writ in the nature of certiorari should not be issued, so as to set aside and quash the imprint order dated 21/2021 passed under memo number so-and-so, respect by the principal of secretary to the government of Assam Revenue Department, as well as set aside and quash the imprint order the 15/10/2014, so-and-so. Then directing the respondents to cancel the imprint notice dated 9/12/2022 issued by ADC Assam Nagaur, as well as subsequent orders, if any, for appointment of the private respondent of Gambura Revenue Village. Then directing the state respondent authorities to appoint petitioner as Gambura. Parasi. Yes, Parasi, please to review the order dated 12/9/2002 passed in WPC number so-and-so, same as the same was passed without hearing the petition and without ordering the merit position of the private respondent. So this matter has to be considered, my lord, and your lordship has power. I have two judgments, my lord. I place it. Para 10 of the Supreme Court judgment can be seen, my lord. That's why we are not questioning the case on merit, my lord. We are questioning the case that review was dismissed for delay. Lordship has the power to do it, my lord.
We're not disputing that.
So
but
that's
when
Sukhdev
they-
Singh, the
when they-
judgment, my lord, para 10 can be seen, my lord. Para 10, Sukhdev Singh. Para 10, lordship may be seen, Sukhdev Singh, Supreme Court judgment.
The other contents of Mr. Gopal Singh pertains to the second order of Khosla J, which in fact reviews his prior order. Huh? Reviews his prior order. Learned counsel contains the does not confer any power on the High Court to review its own order and get the decision on the High Court for decision for review which
So the power is there, my lord.
Power is there, but not this way, this manner.
No, power is there, my lord. That's
No,
what my
power
prayer
is
see.
there under 226, the
Yes.
High Court. But thereafter, what is
Whatever
the,
it is,
what is
my
the
lord,
procedure?
whatever is there, my
You
lord.
file a review in that case. Before the appropriate bench. You
No,
file
I-
a review, it will be placed with the appropriate bench. So long as, see,
No,
we
lordship.
have the rules also.
No, lordship may see.
Nobody is disputing. I told you, you said that you will show something different. It is regarding the power of review under Article
No,
220. That's all.
whether lordship is
And
the
on the
question to
facts
be, my
of
lord,
that case,
whether
it doesn't say if a coordinates bench passes an order, I can review it. Automatically, it's not that.
that is
There
there,
is
my
High Court,
lord.
you know, you are very well.
I understand that, my lord, but
High Court rules provides what?
no,
In
review
case
of
of retirement,
lordship may see.
in case of demitting office only, the other bench can take the review.
No, lordship may see that order
Or
passed by
in
the
case it
coordinate
is
bench.
in a different bench, and when there is an urgency. Otherwise not.
No, I will be remedialess, my lord, otherwise then.
You file a review.
No, review of, I am not questioning, my lord, because Gaubura, that has been appointed, my lord, I am not questioning that. Let him be there as a Gaubura, but my question on the basically.
No, it will have a for review for what?
No,
For
160
review for what?
No,
Review against the appointment only.
yes, correct, my lord.
Appeal.
No, that's why, my lord, because learned single judge, my lord, subsequently, my lord had given a judgment that place of residence is not a factor, my
You
lord.
have rightly prayed for review. It should be placed before the appropriate bench, but not great petition.
No, lordship say
First,
page
you have to
45, my lord.
overcome that. Not possible. And I think by this.
Then the lordship may pass an order that
See, if I had to pass.
because because
I
my
had-
understanding, my lord.
Sir, if I had to pass, writ petition will be dismissed. You think about it.
No, lordship may say if tomorrow, my lord, because that's my reading of the law is that, my lord, because previously learned single judge has said, because I have been rejected because my place of residence is not there, my lord. But learned single judge, my lord, page 45, lordship may see the elaborate judgment after hearing us, my lord.
Thereafter, 2022 judgment
22.
orders.
No, that is correct, my lord. I am not disputing that, my lord. But finally, my lord, then lordship may see that
So you
para
may
8.
as a petitioner, it may not be fault of the petitioner because you have made a complaint including
Right.
non-representation.
Right.
That I not understand. Wrongly or rightly, this is not a.
No, my lord, that is in
That
my,
is that may be a good ground for review of that order.
then lordship may make an observation that I'll file a review for that order, my lord.
No, no.
Otherwise, I'll be remedialess, my lord.
No, no.
I'll be remedialess, my
That
lord.
we cannot pass.
Because para 8, page 49, but a learned single judge order continue from page 45.
If you submit, we may record it, but with the liberty to take appropriate remedy, but we cannot pass direction. It would be amount to directing.
No,
File a review.
lordship is not going to decide the case on merit, my lord, here. I'm not asking also your lordship to decide my matter
no.
on merit.
At the first blush, I didn't notice this order, subsequent order, 22.
That's what, my lord,
At
we
the
filed,
first
that's
blush,
what my prayer in the writ petition, my lord, I included
I
para
find
C.
your submission very, very formidable. But because of this hands up side,
Very good, my lord.
so I cannot,
Oh, that's why, my
I
lord.
cannot make you more wise.
That's why, my lord, in para C, I
Sir, you
made a
know-
prayer.
You know better than the court how to go it. Everything is, it's not that this order was passed.
Then lordship, I want that only lordship
Notice
to
was
make
given
make
to
an
you.
observation to file a review against that order, but I'll file it, my lord.
No,
Because that liberty must be given to me, my lord.
no, you make a submission.
No, my lord, then there is a question of delay will come, my lord.
You make a submission. That, sir, that will.
That's what, my lord.
No, we just cannot condone the delay like that.
No, I'm not asking you, that's what
It is up to the court. We'll reviewing the matter, we'll look into it. Whether there is a delay or not. And it's a good ground. Section 14.
No,
Another
correct, my lord.
ground is there. You
That's
can
why,
take
that's
that
why
plea
in my
also.
writ, I have included prayer C, my lord, to review that,
That we cannot.
that order.
That we
And
cannot.
because of that court has.
Who has passed this order? Senior judge is still available.
No, it's not, it's not available.
It's available here only.
He's available.
Yes.
He's there.
So
So lordship has given.
you
some-
withdraw or you'll will, if you want to withdraw with the liberty to file avail the remedy, then
Lordship will give some liberty, my lord. That's what I'm asking, my lord. I'm not asking the lordship to decide the case of merit.
no,
my
that's what I'm saying. If you pray for that to withdraw the writ petition with the liberty to avail the remedy as may be under the law, we'll provide that
No,
liberty.
but my question will come, my lord, and again, my review that it has been dismissed on merit, on delay, my lord. Then that question will be, there's no meaning, my lord, because
No, that cannot be considered. You have missed the bus because of this order. We cannot overturn this by sitting in a coordinate bench.
because I will have no other ground, my lord.
You have a ground,
other-
suppose if, no, that is admittedly you have received it may be fault of your, fault of the lawyer, of the petitioner.
Yes,
I think one of the good ground, either for appeal or review, then consequences will follow.
No, then, my lord, only one problem, my lord, then how come that bench cannot consider the other part of the order?
No,
My
until-
review.
See, until,
This is nothing to do with the review, this order, my lord.
that's what I'm saying. That is the reason.
That was,
the-
that is the reason I
see,
came before this court, my lord.
Proceedings. Bona fide proceedings under section 12 and 14 of the Limitation Act. You have bona fidely pursuing these proceedings, this writ petition, with a hope that this court will entertain or accept that to go for hearing of the review, right? I'm not saying that you cannot challenge this. You have the challenge, but you have to miss the bus until that order is passed, reviewed. Because that court has subsequent
that is
court has taken on record that review has not been filed. All right. Why your review has not been filed? What is the reason? Fault of the lawyer. What is their judgment? Client cannot be made suffer
Yes.
due to the fault
That's
of the
correct,
lawyer.
my lord. only thing if.
That is the only case you
There-
supporting you.
So far,
It's either even for consideration against this dismissal of your review petition on the ground of delay. That's the only consideration I was on. The duty for the lawyer wise you should the client should suffer. But problem is this.
there
Page
is
70, 69.
69.
Lordship will see. So far review of the last order, Lordship, as the Lordship say, that will not help me, my lord, otherwise also.
Huh?
That will not help me, but there is nothing to review this order.
See, once it is reviewed,
Because that is an independent proceeding which I am very questioning, my lord.
but ultimately,
Filing
suppose
review,
what is review for? What is review for?
review. But that power is there, my lord.
Proceeding,
Or
every-
that government
Well,
has
you know,
power.
every proceeding has a
But
bearing
only-
to the merit only.
Yes, government has
Suppose
power.
if review is allowed,
Yes, my lord.
what would happen?
Then the review is allowed, then court will decide, but the authority will decide as
What would
as per
decide?
law, my
They
lord.
cannot decide against this. Because at that point of time, because there is no review, and considering into taking into account all the, I mean, the material facts at that point of time, court is directed to issue an appointment order.
If that is there, then again I
That
have
will
to
be
come to court, my
contrary.
lord.
Suppose even if your review is allowed, they cannot pass.
No, then again I have to come to court, my lord. Or under 226,
No,
I'm
no.
challenging this, my lord.
We cannot overturn this.
That's what my lord
I'm
instead
sure.
of,
No. I said, at the first blush, I find your submission very, very formidable. I said, why? Go back, hear it again. But this 69, page 69. Ordinary bench.
let it be taken Friday, my lord, I will take instructions over.
Think about it.
Friday, my lord.
I'm not forcing you to
I
withdraw.
understand.
Otherwise, I've heard you in view of this. I don't have to go into all this thing. I'll record your judgment also. But it will be dismissed.
Friday, my lord.
Pardon me, sir. Zero, that is senior counsel, assisted by Mr. Learned counsel for the Monday. And all
I am agreeing for response number
after arguing the method for some time,
1, 2, and 3.
arguing the method at some length. Learned counsel Mr. Zero request for listing of the matter. On Friday.
Friday.
Day after.
Matter will be kept in part.
In view of the, no, in view of the fact that the coordinate bench, in view of the order passed by the coordinate bench of this court, on
my lord.
12/9.
12/9/22.
2022 in WPC so and so.
4542/2021.
But instead of Friday, let it be on Monday, my lord. Lordship will keep it as a part-time, my lord.
Part-time.
Part-time.
Part-time, my lord.
No, once it is listed, we'll not hear you again. We're only waiting for your
I will get the
instruction only.
Let it be on Monday, my lord.
Monday,
I'll let you.
Monday, huh? No hearing.
No, yes.
I'll try to get judgment, my lord.
No hearing. No further hearing. In that case,
On the question of law, I'll just.
Let us not complicate the issue.
I will try to change the law.
See, look at the practical, forget about the law. Simple thing.
I understand.
Even if your review is allowed, what would be consequences?
Again, I have to.
Appointment of Gaupura.
But again I have to come to court.
Since you have not filed an review as directed by the court, maybe not your fault. But then the court has, while taking note of that fact, has directed the authority to issue an appointment order, which has been issued already. So until the time it that it overturns. All right, that we cannot overturn. It's either the court who passes the order or the higher court. I mean, higher forum. Higher forum only.
I'll
Not-
check up.
Not by us. Not by this court.
Highly obliged.
May I please, Your Honor?
Yes.
Matter pertains to provincialization of service lordship.
Yes.
And this is the second round of litigation lordship.
So,
In the earlier round of litigation lordship, petitioner challenged a provincialization order lordship, whereby a service of junior teacher was provincialized, leaving behind the petitioner lordship. And
you are
thereafter,
senior.
I'm the senior lordship.
Which you are you assistant teacher? Which subject?
Assistant teacher lordship.
2017.
Yes,
In
thereafter,
terms of
lordship,
2017 Act,
lordship, there is direction lordship.
it's okay. 2017 Act,
Yes, there is direction to consider my case.
it's okay.
In accordance with
Consideration,
2017
they
Act.
rejected your case. Have they considered?
No, lordship. They have not considered my case yet. Lordship.
Then if you have not considered,
Yes, madam.
as per the direction,
Yes, madam.
you file a contempt.
Lordship, they passed the order, lordship, impugn order, lordship.
So that has been considered and rejected. It's a consideration.
No, lordship.
What is that?
Thereafter, lordship, I filed the case petition, lordship. Your impugn order is, lordship, at page 50, lordship.
So,
And lordship, first, lordship, can I, lordship,
no, it's okay. We will first see what is the ground of rejection. Yes. Detail.
lordship, 11 para 51, lordship.
In view of the above facts and circum, DSC Demaji has not recommended name of Nili Kanta Chutia for provincial services for Act of 2000 as amended 2000. On the other hand, all the post of teachers in something like this and also studying the science teacher who hence concluded that your case was not even considered in 2011 Act, under the 2011 Act.
Yes, lordship. But direction is to consider in accordance with 2017 Act, lordship.
Where is it?
And that order, your lordship will find at page 47, lordship.
By applying the first.
Page 47, 11 paragraph, lordship.
Maintainable. Not maintainable.
Direction is
Filed by whom? Filed by you.
filed
Writ
by
petition is not maintainable. However, the purpose of
page
provincialization
47.
has been declared after and the subsequent assembly regulations has been enacted in the meantime. The response has been considered of the if otherwise is eligible. Yes.
My lord, in the earlier, my lord, litigation, my lord, that is WPSC 890/2014, my lord.
Forget about
Number
sir.
43,
Now
sir.
the court
That-
has dismissed the writ petition
My
for
lord,
not being
that
maintainable.
has already
Thereafter,
decided,
thereafter direction was given in view of the fact that you have enacted new law,
my lord.
2017.
17.
In terms of that, you have to consider.
My lord,
So what you have, why you have rejected is
my lord,
that since his case was not recommended by DSC,
not recommended by DLC.
DSC
and
in under the 2011 Act,
2011 Act also, my lord, not recommended. Because, my lord, why not recommended? My lord, find it page number 50, my lord. Page number 50, my lord. That person, my lord, in the table, my lord, Provito Sutia, who is the respondent in the earlier writ petition, my lord, he is junior to, apparently junior to the petitioner, my lord. Subsequently, this petitioner has assailed it, my lord. This honorable court has held that his appointment cannot be challenged, my lord. This is in the order, my lord.
it's okay.
And,
This image
and
is-
other two person, my lord, Tolikto Sutia, my lord, he is senior, my lord. Dharmendra Sutia, he is science teacher, my lord. This post is vacant, my lord. The order said that, my lord, since he is the not science teacher, my lord, only science teacher post is available, therefore his provincialization cannot be considered.
He is what?
He is the assistant
Assistant
teacher.
Where it is?
Assistant is,
Assistant teacher can also be a science teacher.
no, my lord. Science teacher, there may be appointed as a science teacher, my lord. He is from science
We have
background.
found something different. Where it is? What is the main reason? What is the main ground?
My lord, that ground has, my lord, stated, my lord, in the order itself, my lord.
Tell us, show us now, sir.
My lord.
You said page 50.
Page 50, my lord.
Let us not go back to this earlier writ petition.
My lord.
That was dismissed,
That
not
was
maintainable.
My lord.
However, a direction was given to consider under 2017.
2017.
Now, how you have considered? So us.
My lord, that second para, the name of the petitioner Nilokanto Sutia was not recommended by the District Scrutiny Committee.
For provincialization
For
of service as,
provincial service
as per
2011 as
2011.
amendment in 2012, my lord.
Hmm.
Once, my lord, he has recommended by the 2011, then question of the consideration is 2017 will come, my lord. Because District Scrutiny Committee, my lord, both act has preferred, my lord.
It's not like that. 2017, you can be considered.
Considered, my lord.
Court has never directed to consider you just because he was considered. He was not considered, therefore, was not found to be entitled.
No, my lord, what I am saying, my lord, because, my lord, whether it 2017 Act or 2011 Act, my lord, District Scrutiny Committee recommendation is required, my lord. Here, my lord, why petitioner has been recommended, my lord?
The committee have that unbridled power of discretion to recommend anybody.
No, my lord.
Any Tom, Dick and Harry.
No, my lord, District Scrutiny Committee recommended who is eligible, my lord.
So how is not eligible?
My lord, page number
Just
50.
because he was not recommended by the District Scrutiny Committee in 2011, it cannot be ground. That's what I'm saying.
My lord,
I
therefore, my
find
lord,
that there is the only ground.
My lord,
So
there-
show us that there is not a ground.
my lord, therefore, I am relying the page number 50, my lord.
Yes.
This table, my lord. Serial number 1, my lord. Although he is the junior, my lord, his service has been provincialized as a headmaster, my lord. And serial number 2, my lord, he is the senior, my lord, assistant teacher. And serial number 3, my lord, Dharmendra Sutia, he is the science teacher, my lord. And other person, Debo Kumar Bhuya, assistant teacher, he is senior to the petitioner. And that person, my lord, serial number 5, Hemojyoti Bhuya, he is the Hindi teacher, my lord. Now I am saying that, my lord, there is no any post of assistant teacher, my lord. Only science teacher post is available, my lord. He is not
What do you
qualified for
mean
the
by
science teacher.
assistant there? Only 3 teachers are required to be appointed.
Only 3 teachers, my lord. 3 assistant teachers.
One teacher or the tutor. One is science, science and mathematics.
My lord.
Math, huh?
My lord.
Other one is social science.
Social science.
Third one is language.
Language.
So all these 3 posts are filled up.
Filled up, my lord.
Oh, by
that's the
whom?
difficulty.
By whom?
My lord, by my lord.
By whom?
This one, my lord. Probito Sutia, Tolikko Sutia, and
Probito Sutia is for?
Assistant teacher. 3 assistant teacher, my lord. Probito Sutia is a HM. Tolikko Sutia, assistant teacher. Number 3 is vacant, my lord. Debo Kumar Bhuya, assistant teacher. And my lord, 5, he is the Hindi teacher, my lord. This post has filled up, my lord. Allotted post has filled up. Only science post is available, my lord.
I'm not getting it. See, Probito Chutia HM is no issue.
No issue, my lord.
He has been appointed as
headmaster, my lord.
Only, no issue.
No issue, my lord.
That is in clause. Then
Tolikko Sutia, he is the assistant teacher. He is the senior to the petitioner.
So
therefore, he has recommended for the provincialization.
So he has been appointed.
He has
Provincialized.
Provincialized.
Which subject?
Provincialized.
Which subject?
Assistant teacher, as an assistant teacher, my lord.
Is it the requirement of rule?
My lord. Only three posts of assistant teacher.
3 posts of assistant teacher of what, sir?
My lord, from that
Science and mathematics.
My lord.
Social studies, language.
My
So assistant teacher of what?
My lord, that part, my lord.
Have you gone through the rule? I mean the act.
My lord.
Section 3(1)(11).
My lord. Page number 38, my lord. 38 on the top, my lord. Page number 38, my lord. This is the provincialization order, my lord. Relevant portion from page number 37, my lord.
What do I want to show this from here?
Page number 37. This is the provincialization order, my lord, where service of the provincialized as per the 2012 Act, my lord. 12 Act, my lord. This is and page number 38 will be relevant, my lord, on the top, serial number 6, my lord.
Sir, show us the 3 posts are filled up, right?
My lord.
Or are you saying the science post is still vacant?
Still vacant, my lord.
So, you said that assistant teacher has been appointed.
Appointed, my lord.
In which subject?
No, my lord, in 2012-11 Act, my lord, there was a no subject preference.
Okay.
Subject preference come in the 2017 Act.
Yes. So you have been directed to consider while dismissing the writ petition.
My lord.
Being not maintainable.
My lord.
Directed to consider as per the 2017. So when science teacher is vacant, the post of science teacher is vacant.
Vacant, my lord.
Why don't you consider his case?
No, my lord, science
Just
teacher, my
because
lord.
he has not been recommended under 2011 Act or 12 Act, you
No.
cannot.
No, my lord, there is a separate qualification for the science teacher, my lord.
So as he's not a science teacher.
He is not a science teacher, my lord. His
So as-
appointment as a assistant teacher, my lord. My lord,
So
may come
as
to his
science teacher.
appointment order, my lord.
Yes, you show us you are a science teacher.
My lord, no, he is not a science teacher, lordship.
So,
Assistant teacher, lordship.
so
Lordship,
dismiss.
my submission is, lordship,
Unnecessary wave.
only one submission, lordship. My submission is to let them comply this.
First, you have to apply. This has been complied with.
No, lordship. Already, lordship, there is vacant, lordship. Who start vacant, lordship? Already a headmaster has retired, lordship. He has retired, lordship. And
Retired, why
one more
not?
teacher has retired, lordship.
It's up to them to fill up.
And,
You first show us that you have to be considered under science teacher.
I'm not claiming for science teacher, lordship. My
Huh?
petition is not for science teacher, lordship. I'm not claiming for science teacher, lordship. I'm not claiming for science teacher, lordship. My petition is for assistant teacher, lordship. They have already taken push, lordship. My only service prayer is, lordship, let them comply this order, lordship. There is a direction to
There has been complied
There
with,
has
sir.
complied.
They have not complied, lordship. What 13.6, lordship? 13.6 says, lordship. 13.6 says, lordship. Lordship, you can see 13.6, lordship. 13.6, lordship, as per the new act, lordship.
Yes.
It is the lordship. 13.6 says, lordship.
What has not been
Place the
complied
case
with?
before the
Court's
DLC, lordship.
order which is not been complied with?
My lord, as per the 13.6, lordship, they have to place my case
First tell
before the
us,
DLC, lordship.
tell
DLC.
me which is not been complied with. Not complied with the court's order or the provisions of the act.
Yes, my lord, as per 13.6, lordship, they have to place
Not
my
yes
case.
or no, not yes, not. Whether according to you, whether the court's order has not been complied or the provisions of the act has not been followed, according to you, which one?
My lord, according to me, my lord, they have not complied this order, lordship.
Which order, sir?
Page 47, my order, lordship. Page 47, lordship.
No, that has been complied with.
Not complied,
And
lordship.
complied with and rejected.
Yes, thereafter
Your
I
case.
filed this writ petition, lordship.
Therefore, we are considering, sir.
My lord, my submission is, lordship, as per the order, lordship, my case ought to have been placed before the DLC, lordship. But they have not placed my case DLC, lordship. As per section 13.6, lordship, my case ought to have been placed before the DLC, lordship. They have not placed my case before the DLC, lordship. That is my only submission, lordship. Let them place my case before the DLC and DLC take a call, lordship. They may reject my case also, lordship. 13.6 says, lordship, that to scrutinize and verify the documents of the petitioner, lordship. They have to place my case before the DLC, lordship, as per the order, lordship. 13.6, lordship.
See, you want your appointment or you want just a formality process to be followed.
Yes, madam, let DLC take
What
a
your client wants.
DLC have to decide, lordship.
Is he only wants that the formalities of the process has
Yes,
to be
madam.
just followed,
Yes,
nothing
madam.
else?
Yes, my lord.
He doesn't want anything. He doesn't want to be appointed as a teacher.
If he is eligible,
Provincialized as a teacher.
if he is eligible, lordship, then they can take a decision, lordship. And if he is not, lordship,
He said it's not eligible.
my lord,
What more do you want?
but they have not placed my case before the DLC, lordship. As per the also order, lordship, they ought to have placed my case before the DLC, lordship. And section 13.6 clearly says, lordship.
Sir, we don't issue futile writs. Futile writs we don't issue. First, you have to establish that you are entitled to be appointed. Otherwise, somebody comes, a class 10 students, or an unemployed youth comes and say, let my case be considered and placed before the court. I mean, the authority. Should I pass that order?
Therefore, my
First, you have to establish that you are entitled to be appointed.
therefore, my humble prayer before your lordship is to place my case before the DLC.
No, no,
lordship.
we cannot
Let
pass like that.
DLC take a decision, lordship.
No. That's why I'm exactly trying to tell you. We don't issue futile writs. What do you want? You want to be provincialize your service.
Yes, madam. My prayer is for provincialization of service.
So, this order is passed by the director.
This order was passed by director. Yes, lord. They are saying about the old act, lordship. There is no whisper about the new act, lordship.
No, that has stated in the last paper.
Has the claimant petition for provincialization of services against Babili Adarshi School under the post name of the could not be considered and hence thereby rejected.
Kindly see 36, lordship.
We'll place before the district school committee.
Yes, sir.
Director.
Only
No,
only
member secretary,
Huh?
inspector member.
This 6 is basically for initial prayer. You read entire provision. Place before the school itself, first scrutinize and prepare the list of venture school institutions. First, list of all venture established
Yes, madam.
within the district, which are eligible in terms of the provision of district. Shall thereafter proceed to scrutinize and verify the service records.
Verify the service. Yes.
All. They have to redo it again. Again, they have to prepare the list of all the venture schools.
Yes, madam.
For you.
Yes, madam.
Only for you.
That is the direction.
This was intended.
Madam.
Intended at the initial stage.
And that is the direction, lordship.
You file an contempt. If it's not been complied with. You are saying that it has not been complied with. The court's order has not been complied with, right?
Madam.
That's the only your submission.
Yes, madam. Only submission. My limited, only my.
So file an appeal. File a contempt petition. We'll see whether there is a compliance.
My lord, order was passed on, my lord.
He lately came to know about this order also. He lately came to know about this order also.
So
earlier, engaged counsel was not appearing Lordship in this matter also. So thereafter, Lordship, COVID and other issues came also. So he could not find in time also.
we are not, read court doesn't sit as an executing court. All right. That is your only prayer. Because we wanted to, this court wants to consider to give you a substantive relief. You are just only formalities, process of formalities to be complied with without there being any claim for substantive relief, right? And if your submission is only that as per the direction, the authority has not considered, complied with, you file a contempt petition. And if you have missed the bus, you have missed the bus. That's all.
2018
We'll take it up at 2. Think over it.
Then it's another day.
You are here for, see, all of us here for the litigants. We'll go for substantive relief, not the mere formalities. That would not, serve the cause of justice. That is at least this court believes. I don't know what about it. Nobody comes to the court for fun. They want to really, maybe they are entitled or not entitled. A lawyer's duty and the court's duty to go for the substantive justice. Right? Right. It's over. Okay, this way. We'll take it up at 2. Think over it. Next.
Oblige.
Yes.
May I please, Lordship? My Lord, in this case, petitioner was accredited social health exhibit, ASHA, my Lord. He was appointed in the year 1/12/2006, my Lord. My Lord, during her service, my Lord, an FIR was lodged against her, and he was arrested in connection with that FIR. But however, after release, my Lord, she filed an application to allow her to resume her duties, my Lord. But till date, she has not been allowed to resume her duties. My prayer at this stage that, my Lord, her representation may be.
Representation, 6 and 7 not developable representation, NRHM.
Now, my learned friend is saying that this representation should have been filed before the respondent number 6 and 7, my Lord.
Lordship, this case, it is under NRHM. Representation has to be filed before the respondent number 6 or 7. He filed before this joint director head services, but it is ASHA workers are under NRHM.
NRHM.
Yes, my friend representing NRHM.
You file an application.
Yes.
Withdraw this. We'll give you a liberty.
That will be disposed of directing the petitioner to file the appropriate application before the respondent.
Not Mr.
AHMR.
Learned counsel for the petitioner. By challenge made in this petition. Any order has been passed?
No, my Lord.
No.
Has been, is to the action of the respondent authorities in not allowing the petitioner to resume her duty as ASHA worker. Please stop. You read all of them, huh? Next paragraph. The case of the petitioner is that the that she was appointed as accredited social health activist. In short, ASHA, by the order dated 2011-2016, with effect from 01-12-2006, not 16, 2006, and was posted at Burbando Primary Health Center in the district of Morrigaon. Again, you were posted where? This is something Lahorigarh.
Lahorigarh, madam.
Thereafter, you were posted at Lahorigarh.
Lahorigarh.
Lahorigarh and Burbandar is something different
Different.
primary health center.
Yes.
Different health.
The petitioner was thereafter posted at Lahorigarh Primary Health Center. While serving at Lahorigarh Primary Health Center, an FIR was lodged against the petitioner. Which was registered as Lahori PS case number 623 of 2021 under section 312, 314, 336, 419, 302 APC. Read with section 5 within bracket 2 bracket close 5 3 swings 5 bracket 5 3 bracket 3 bracket close public 5 within bracket 4 bracket close of medical termination of pregnancy Act 1971. Pursuant thereto, the petitioner was also arrested and released on bail on 10/12/2021. Arrested on what? When? Arrested on? Mister?
Yes, madam.
When you were arrested? Arrested on
19/10/2021.
On Mr. Next one. It is contended that after release from the jail, the petitioner went to resume her duty. Petitioner resume her duty. Not went, resume her duty. But she was not allowed to join. Mr. The petitioner having no alternative approached the authorities. Thereafter filed a representation, particularly before the Deputy Commissioner Morrigaon, which Morrigaon, Mr. Who has forwarded your application?
My lord, page 24, my lord. And your lordship will find page 23. Earlier representation was communicated, forwarded by the joint director to the joint director by additional deputy commissioner, page 23.
You have filed before the petitioner or what?
Initially, before the additional deputy commissioner forwarded it to the joint director, health services.
What is this order, page 19?
This is a bail order. This is bail.
Page 19, bail order, my lord.
Bail order.
Bail order.
The application of the petitioner was forwarded to the Joint Director of Health Services, Morigao, by the Additional Deputy Commissioner within President Health Morigao on 06/03/2022. Listen, having not been considered, with this last, your last
Page 24.
No, in place 47.
the petitioner approached the subdivision medical and health officer Lauriga, PhD, Morigao. For allowing him to join her duty and for release of monthly honorarium. However, soon has not been considered as a bill. Mr. So-and-so, learned counsel, submits that the prayer of the petitioner, the simple prayer of the petitioner is for a direction to consider her representation while before the competent, before the respective authorities. and allow
Respondent, respondent 6 and 7.
before the respondent number 6,
6.
and 7, and allow her, and a direction may be issued to allow her to continue as ASHA worker.
Yes.
And pay the entitled honorarium. Next paragraph. MS.
S. Sharma,
S. Sharma, London State Council,
Standing Council for Health Department,
Health Department,
and says for a minute.
and
Respondent 6 and 7.
respondent 6 and 7
It does.
for
NRHM.
Standing
National
Council.
Police.
And Standing Council. And anybody else? Only. While while not objecting for a direction to dispose of the representation, however, submits that the petitioner has not filed the representation before the appropriate competent authority,
Yes.
as it is indicated that the petitioner has filed her representation before the Deputy Commissioner
Deputy Commissioner.
and the Subdivision Medical Health
Yes.
Officer, Lahori Morigao. Whereas the competent authority to consider the case of the petitioner is
Respondent number 6.
respondent number 6, that is IE,
Mission Director, National Health
Mission Director, National Health Mission,
Mission.
NHM, Assam.
Yes.
Mr. Next one. Having considered the submissions of learned counsel to the parties, I'm of the view that the representative can be disposed of with the direction to the petitioner to file, approach the appropriate authorities, namely Mission Director,
Yes.
the Mission Director NHM. Respondent number 6 here. Mr. Accordingly, as the petitioner appears to have not approached the rightful authority, approach the appropriate authority. Accordingly, the petitioner is directed to file her representation before the Director, Mission Director, and HMI, respondent number 6, placing her grievances, within a period of
1 month.
1 month from today. If on filing of on receipt of the representation that may be filed, that representation has directed herein above, the mission director said so, and it's himself consider and dispose of a representation within a period of 2 months from the date of receipt of the
Lord.
representation. With the above that. With the above observation in direction. Representation disposal.
Lord.
Deep blue.
Matters pertaining to Itanagar bench, supplementary hearing, IA Civil 182 of 24.
Again, there is a mistake.
Same, I thought,
We'll list it on Friday
very well, my lord.
for delivery of the order.
Very well. Very well.
And the IA also, my lord, because my IA is also listed.
IA for what?
IA for calling of the records. There is an order by your lordship.
First, clear up this.
Yes.
That is.
I thought-
My lord, I also, let me,
but
my lord, there I also have an objection. I also
So
have an
what I'm
objection.
saying, my lord, my learned friend can file his objections, and on that day, my lord, we
Just
can
wait.
pick.
I will not file my
Mistake,
objection.
mistake.
I will file my objection.
Mistake, there is a mistake.
That's
Again, another mistake. So it's, everything is ready.
That's not a problem.
But
my lord.
I
We are
find
not.
that
And
it
my lord,
is-
my
it is for
objection, my lord, my objection, my lord, my objection against their interlocutory application for inspection would be subject to the nature of the order my lord is likely to pass in this very particular
We'll-
case,
certain things-
because
but just
certain
wait.
things very well, we know very well.
This is an election petition.
List it
So
for
what if
delivery
it's an
of
election?
the order on Friday. Thereafter, we'll fix the date, whatever.
Yes.
My lord, I'm only.
But there is another aspect, my lord, I'm sorry.
Let me, sir. Let me.
Very well.
No, you are senior.
It was an ex
Yes,
parte, it was an ex parte
But-
proceeding. You obtained an order
Just
from the
just a
honorable
minute,
court.
Sir, I'm just addressing the court. My lord, this is an election petition. There are a time is there in the act. My lord, I'm only saying, you know, certain things.
Sir, what concerns of that?
My lord, I'm only saying.
Cannot help it out.
I'm sure, my lord.
Are you trying to say that the court, because of the court is?
I'm not at all. I'm not at all. I'm not at all doing it. I'm only saying, my lord.
Cannot blame it on.
You know, certain things can be done parallelly. I'm only saying that to save time, my lord. My learned friend has certain objection. I'm only saying that he may file his record,
Sir, it's
whatever.
all right.
I cannot.
Today, wrongly, this has been listed for supplementary hearing.
That's
Should
absolutely
have
okay,
been.
my
It
lord.
should not have been.
That is absolutely. I
So
bow down.
I said there's a mistake.
I bow down, my lord. I'm not saying anything.
Therefore, we'll list it for delivery order
That
on
part I'm not even
Friday.
saying. I'm not saying anything. Lordship may fix it for hearing, my lord. I'm only saying, my lord, he may file his reply in the meantime, which will shorten the time.
No,
That
no,
will only help.
on that day.
Yes, because
Friday.
Very
because he can't, my lord, subject me to his dictation as
I'm
to
not
on that
subjecting,
very.
I'm making a
Of
prayer.
course,
I'm
of
entitled
course.
to make a prayer to my lord.
May.
You cannot.
You
I
might
am
very well
entitled to
make a
make
prayer.
over
You
this,
might,
my lord.
you might very well make a prayer.
It's okay.
And it is for me to
I'm
make a
making
submission before
I'm
my lord.
making a humble submission to my
Please,
lord.
And I'm equally making a humble submission that I will not be
Thank
doing
you.
it subject to the order
My
of my
friend
lord.
should not.
And
There is no question of should not.
PK Tiwari, learned senior counsel assisted by
You, particular.
for applicant respondent, applicant respondent, and Mr.
Rituraj Biswas.
Biswas and DJ Kapil for opposite party public election petitioner. The matter has been listed wrongly for supplementary hearing. Therefore, let the matter be listed on Friday, i.e. 21/03/2025 for delivery of order.
Very good.
Right. Unnecessary, why you are?
No, my lord, I'm only saying, my lord, because we have to.
Again,
But already 1 year, my learned friend has taken with his applications 1 year, my lord. That's why I'm just pressing. it.
As if I am responsible. If
We
you file
have-
election petition, we will explore
If
all
he-
avenues.
If he can help us, my lord, we can expedite the matter. That is my.
He's
That is
helping.
my.
We are here to help the honorable court
We
to
just
decide the
try. We
issues.
cannot help which beyond our reach.
That's it.
Absolutely.
Beyond our control.
Absolutely.
We cannot.
It was not on the court, my lord. It was only on. Between
On
us.
us also,
No,
because I have
for
my,
everybody,
Right.
including you,
Right.
not
Absolutely.
only him, not about the court only. It includes you also.
it's our also duty to
Well,
ensure
try our
my lord, that
best.
Very well. Friday, we will come back.
Yes, sir.
Letter relates to the
22.
my lord,
22.
22.
Yes.
Petitioner was selected and appointed as headmaster of a particular school, my lord.
Hmm.
He has joined immediately, but his salary has not been paid from the date of his joining.
Yes.
Against that, I have posed this honorable court, my lord. They have admitted that I have joined long time back on 17/3/2012. Function letter is that is
Till
an extra one.
Till you are seeking payment of your salary,
Yes, my lord.
area salary.
Area salary.
So from which date to which date?
From 17/3/2012.
As a headmaster.
Yes, my lord.
Headmaster, you get a better, higher pay.
Yes, my lord. I was entitled.
Otherwise, you have received the,
Other salary has been paid, my
as a normal teacher you have,
Yes.
only as a headmaster.
Headmaster.
Yes.
Lordship, instructions is awaited, your lordship.
What awaited?
But here, your lordship, he has from 2012,
Let
but
us
he
see,
has joined
is
it
your
in 2000
appointment as a
and he
headmaster.
joined it in 2014, your lordship. As per the
Have you paid from 2014?
2014, I think he's being paid, your lordship.
Huh?
He's being paid from 2014.
As a headmaster?
Yes, your lordship.
That's why I'm
But here the petitioner is claiming from the year 2012, your lordship. He's claiming from 2012.
from the date of his.
Yes, your lordship, but he
joining.
didn't join, I think so.
Are you sure? Be sure and make a submission.
Yes, your lordship, that's why I'm waiting for
Disposing
my.
of the matter.
Yes, your lordship, that's why I'm waiting for my instructions, your lordship.
Yes, where is your appointment?
Appointment is page 18, annexure 1, my lord.
Page?
18, 1/8. Annexure 1.
That too. The appointment is the pursuant to the High Court's order.
Yes.
Yes, your lordship.
Promotional post, my lord.
Yes.
Next, annexure, my lord, he has joined.
On
17 March.
After 2 days.
Yes, my lord.
Yes, then
My lord. Thereafter, he could not take charge due to certain administrative difficulty, my lord. And ultimately, my lord, annexure 5 at page 27. The director issued an order to allow the petitioner to take over charge of the particular school.
27.
On page 27. Because he could not take charge due to certain administrative difficulty, my lord. And on 23rd December 2013, my lord, the director issued an order allowing the petitioner to take over charge. And the last line is important, my lord. In the event of in-charge headmaster not delivering the charge, he will assume charge immediately, unilaterally. The last one.
Yes. Then when did you take
Even
the
then,
turn?
he was not given the pay scale.
Lordship, let's come to page number 44, your lordship, annexure 13.
Yes. My lord.
You have taken the charge on 28/5/2024.
2014, your
That
lordship.
was due to certain administrative reasons, my lord.
This your order itself says.
No.
With effect from the date of taking over charge as regular headmaster subsequent.
My lord,
officer.
I had joined, my lord, in the year 2012. I was
You have
willing.
not served.
Yes, my lord, that is true, my lord.
You have not served.
Yes, my lord.
How can you be paid? Hard mister.
My lord, in that case, I may be allowed to place one judgment. When the petitioner is willing to join, willing to serve, and he was not allowed to serve in that case.
You are saying that it's due to administrative
My lord,
issues you could not join.
no, I have joined, my lord, that is admitted position, and they have submitted their letters.
Have you challenged those administrative board? See, it's for payment of the salary as a headmaster. And your provision clearly indicates that it should be from the date of taking over charge. Wrongly or rightly, you could not
That is,
take over the charge.
My
So when you have
understanding-
not served as a headmaster, how can you be paid?
no, my lord, I was all along willing, but due to the reason of the
Willing is something different. Your promotion order clearly says from the date of taking of the charge. Not mister, you are disposing of.
one case may be referred, my lord.
What does it
And
say?
that- Because no work, no pay is not applicable in such cases. Where
I'm
the-
not saying that no work, no pay.
Because
I am not referring to that.
my lord, they have stated that I was not in serve,
I am not saying.
but I was all along willing, because I had joined on that day. It was admitted fact that I had joined in the
I am
2000.
deciding on the facts of this case, that your promotion order, that to pursuant, which you were pursuant to the court's order, which you were granted, promoted, clearly say that it should be from the date of taking over charge. Admittedly, you could not take the charge, although you have tried.
Yeah. My lord, there was no fault on the part of the petitioner, my lord.
But then problem is you didn't know.
Very up to your lordship.
Yes,
That is my submission, my lord.
you are returned now.
No, not yet. Retired, my lord.
You are returned. You are getting all other benefits.
Yes.
Don't worry. Enjoy your evening of your life. Pursue better things. All right, we'll dispose it off.
Yes.
Hard mister. Learn concept to the position. And Mr.
H. P. Your lordship, for all the respondents.
Learned council. State council,
Yes, your lordship.
and
Department of School, your lordship.
standing council.
Yes, your lordship.
For Department of School Education. By filing this writ petition, the petitioner has spread for a direction to the responsible authorities to no. You see, challenge in this writ petition is to the order dated 09/11/2022, page 44. Being number. No. Challenge made in this writ petition is to the order number so and so, page 44, it is 09/11/2022. Whereby the claim of the petitioner for financial, for payment of salary as a headmaster with effect from 17/03/2012 as headmaster has been rejected. No. this should be not ordered letter, huh? Letter number so and so, issued by the director, secondary education, not school
Yes.
education. Secondary education, whereby the claim of so and so, the administration so has been rejected. Mr. The short issue involves the short facts in the present case is that the petitioner was promoted to the post of headmaster
18 man.
by the order dated 15/03/2012. Pursuant to the order of this court, order of this court dated 10/02/2012 in WPC number 2244 of 2010. Whereby the petition, the date of effect of the promotion to be from the date of taking over the charge as regular headmaster. Mr. It is contended by the petitioner, contended that the petitioner upon his petitioner upon promotion to the post of headmaster, he submitted his joining report on 17/03/2012 before the inspector of schools, NDC Marlborough. However, despite such journey, the petitioner has not been, could not join and serve as a headmaster due to administrative problems, Ultimately, next one, finally, the petitioner had joined on (29/04). You have joined on 29/04/2000.
28/5/2014,
your lordship.
In the present petitioner, 28/5/2014. He was
Okay.
allowed to hold third part.
Your name is?
Konak Sharma.
Konak Sharma is number
There- no,
3.
there were 3 persons, my lord.
Okay.
In that letter. Other 2 persons were allowed to hold charge on 29th, and I was allowed from 28.
Okay, 28/05/2014. Mr. So and so learned counsel for the petitioner submits that the non-acceptance of joining of the petitioner as headmaster pursuant to the promotion order. Non-acceptance and not taking charge as headmaster despite his submission of joining report on 17/03/2012 is not due to the fault of the petition, rather it was due to the administrative reasons. Mr. He submits that since the petitioner was already promoted and submitted his joining report. He ought to have been given provided with the area and salary and other benefits entitled to him as a headmaster. He submits that in the facts of the present case, the principle of equal pay for equal work, no work, no pay, shall not be applicable as the petitioner admittedly has been promoted and joined his has submitted his joining report. The report being allied with the responding authorities, the petitioner cannot be deprived of his entitlement from the date of his joining, i.e. (1702) 2012. Next paragraph. And please, therefore, it submits that the responding authorities may be directed to provide the financial benefits, including the salary as a headmaster of Kamarpuchi High School from the date of his joining. Next paragraph. On the other hand, MS Sweds of Learned Standing Council, elementary education, secondary education.
Secondary, Lordship.
Submits that the petitioner has joined and took over the charge of the headmaster of the same school only on 28/05/2014. He submits that the order of promotion that at 15/03/2012 clearly provides that the petitioner is promoted to the post of headmaster of Kamarpuchi High School in the district of Nalbari. Which will be effective from the date of taking over charge as regular headmaster. Is the petitioner, since the petitioner has not challenged his challenge to the non-acceptance or not allowing him to take charge, whatever on whatever reason, and has accepted his joining as joining that on 28/05/2014. The petition is not entitled for any pay of any pay of salary as headmaster from the date he submitted his joining report on 17/03/2012. Therefore, the petition is liable to be dismissed. I have considered the solutions of the council for the parties and the materials available on the next paragraph. It is seen that the petitioner has been promoted by the order dated 15/02/2024, 2012, pursuant to the order of this court. The headmaster of Amarkuchi High School in Nalbari district with the pay scale of rupees 8,000 to 35,000 with grade pay of rupees 5,100 former and other allowances as admissible with effect from the date of taking over the charge as regular headmaster. Although the petitioner has submitted his joining report after 2 days of the promotion order, i.e. that is on 17/02/2012. Nothing is on the record that he has been allowed to join. He has joined and assumed has taken over the charge as a headmaster till he finally joined on 28/05/2014. It is clearly submitted by the learned counsel for the petitioner. The reason for not being able to take over the charge was due to administrative problems which the petition could not do. The fault which the petition, the fault which could not be attributable to the petitioner. Petition, please. The it is said that for more than 2 years, it appears that the petitioner has not challenged the said action of the respondents for not allowing him to join or take up the charge and headmaster pursuant to the promotion order for whatever reason. Mr. Gupta, and of the view that by this present proceedings, such action of not allowing him to take charge unless clearly reflected by what materials cannot be accepted. And the present proceedings has been initiated for challenging the impugned letter dated 09/11/2022 for modification of the said letter by accepting it to be exceeding the date of joining as 17/03/2012. Next one. Having considered the matters in its entirety, and I'm of the view that the petitioner is not I'm of the view that petition is not entitled to the reliefs of the so far as the modification of the letter dated 09/11/2024. And consequential prayer for providing financial benefits as a headmaster of Kamarkuchi High School from the date of his submission of joining report, that is 17/03/2012, is admittedly the petitioner has joined the headmaster only on 28/05/2004. And the terms of the promotion order clearly stipulates that the petitioner, the promotion will take effect from the date of taking over charge as a headmaster. In view of the law, I find no merit in the resolution. According to the request. Sorry, sir. We'll continue this first.
May I please?
Yes.
The last time the BTC has taken time to file affidavit, your lordship.
What is the matter?
Matter is regarding compensate family pension.
New, as per new notification.
Yes.
My lord, I have an instruction regarding this. The PTC has forwarded to Director of Accounts and Treasury for appointment of this family pension.
Okay, it's for family pension under the rules,
Yes.
pension rules. Pension rules.
No,
Under the pension rules.
it is compensation. Compensation, there is a notification, government.
Under which rule?
There is a government notification.
Under which notification? Latest 2000,
Yes.
September 9.
Yes.
Yes,
It
2024.
is 2017 notification, your lordship. Earlier in the state of Assam, that there is a scheme of compensation appointment that has been abolished. And the new scheme has been started.
That's what I'm saying. It's a notification of 9 September 2024.
No, 14 September 2017.
Indeed. What is the instruction, sir?
Instruction, Director of Education forwarded to the Accounts and Treasury for consideration.
Let's see.
What is that policy notification?
Notification is page 33.
33. Please close. Sorry. Under which clause?
That is 5.3. 5.3.
Where the employee dies before superannuation, the family pension of the family pension must be given. Be paid for period up to the date of bill information of the date of the date on which the employee died. Who is the petitioner?
Why?
Huh?
wife of the deceased person.
Okay. So your case has been forwarded.
At,
But it's way back in 2023.
so I'm just, I came to know today itself, Your Lordship. I have to take instruction, Your Lordship, what happened.
But it's 2023.
Yes. 23, but
More
this is
than
not
a-
able, not sent to us, Your Lordship.
When did you file this writ petition?
It is also 23.
Don't be so big, sir. 12th day of
April,
June.
12th April,
This was after the
after this notification.
copy is given to you, Srimati Sheila Mahato. Are you not Sheila Mahato?
Yes,
Then copy is given to you.
it is stated there, but just I feel it. The Director of Accounts and Treasury, Assam, is also the respondent number 5.
So who is
appearing?
who is appearing? Accounts and Treasury. Sorry. Yes. Huh? Yes, Government Advocate, Mr. Goswami. Yes, you appear. Is there any standing counsel?
Yes, Lordship, we have the standing counsel in Finance Department. I'm calling him, he will come. Just a minute.
Heard Mr. So and so. We're granting them some time to obtain instruction.
Yes.
Learned counsel for the petitioner and Mr.
P. Hazari.
Preferential learned counsel for the state respondents. Mr. P. Hazrika, learned counsel, by placing the communication dated 11/04/2023, submits that the grievance of the claim of the petitioner for compensation family pension has been forwarded. The proposal for compensation family pension of the petitioner has been forwarded to the Director of Accounts and Treasuries, sir. With a copy to the petitioner. However, the learned counsel for the petitioner submits that he has not received the copy. Next para.
Today I received.
In view of the above, the learned counsel counsel representing the Director of Accounts and Treasury, respondent number
5.
5 is directed to obtain instruction.
I am for the 6.
I am one List after 3 weeks.
I am for the 6.
Wait, please, your lordship. In
Yes.
this matter, your lordship, I need a little bit of accommodation.
Hmm.
What has happened, the brief I have misplaced. I've taken a copy now from my learned friend. Can it be taken any other day, your lordship?
Yes, item?
Item 24.
Okay. On the prayer of Mr. Y.S. Manna, learned counsel for the petitioner. Place this matter after 3 weeks.
That's for my.
Date may be fixed, my lord.
Why? What is the matter?
Can be disposed of, my lord. In the admission stage, it can be disposed of, my lord.
What is the matter?
My lord, he is claiming some benefits, retirement benefits. Petitioner was actually dismissed from service, my lord. Then he challenged the dismissal ordering before this court, and that was dismissed, my lord. Then writ appeal was filed. Writ appeal was also dismissed, my lord. And now he has come claiming some benefits, my lord, retirement benefits.
So what is your stand?
We have paid, my lord. All the benefits which is due to him has been paid, my lord.
Then?
Because that is the case he has filed, my lord. We have filed a reply.
They have filed a affidavit. I have taken a copy now. Let me.
Saying what?
that he has been paid all his dues, my lord.
All dues.
All dues has
Nothing
been paid to
remains
him.
to be paid.
My lord.
Nothing remains.
Nothing
to
is
be
remains
paid.
to be paid, my lord.
So,
I have to take the instruction whether that has been paid or not.
okay.
Because I don't even have the brief, so I have taken a copy from a
The-
learned friend.
Considering the extent of the respondents,
My lord.
that all the dues entitled to all the dues which the petitioner are entitled have already been paid. This the comma. The learned counsel for the petitioner is directed to obtain instruction. That's all. That's after 3 weeks.
2 weeks, Lord, 2 weeks.
2 weeks.
Get it out.
That is your lordship.
Yes.
I'm on behalf of Mr. Again.
Huh?
I'm on behalf of Mr. Again.
So,
But in this case, we have filed a reply affidavit on 7/3/2025,
so
but this is not in record now. So
is it so?
significant
Reply.
reply affidavit we have filed.
And a so learned counsel for the petitioner submits that he has filed the affidavit in reply on
7/3/2025.
17
2025.
7
3 March.
07 7/3/2025. However, same is not placed with the record. It's the registry to place the affidavit of opposition. The registry to verify and place the affidavit in opposition with the record, with the writ petition, if it is filed, list after 3 weeks. 3 weeks, all right? Okay.
Give him.
Well, I'm seeking some time, my lord, file affidavit.
What is the matter?
Matter pertains to lordship, the provincialization of the petitioner as principal of Borketri College, lordship. And that speaking order at page number 94 is under challenge, lordship. So affidavit in opposition is required, lordship, in this matter. And moreover, Mr. A.R. Bhuya will apprise the court about other developments, lordship.
Why you, on what ground you have been rejected?
Lordship, no ground as such has been given in the speaking order. Only that,
Or Mr. So-and-so learned counsel for the petitioner.
Yes, that's my
Mr. Is the learned standing counsel?
Higher education.
Higher education. Is granted further 3 weeks time
Yes,
to file affidavit.
like,
May I please? Mr. Last question, respondents has taken time to file affidavit.
What is the matter?
Affidavit has been filed.
What is the matter, sir?
Matter regarding the provincialization of service of the petitioner, my lord. At the time of provincialization, my lord, his post was dropped, my lord, in the year 2013, my lord. Then, my lord, kindly see Annexure 10, my lord. Page 24, my lord. Inspector of the school submitted proposal, my lord. But till date, no.
Where it is?
Annexure 10, my lord, page 24.
Your name has been sent for.
I am the assistant, junior assistant, my lord, of Pollimongal High School.
Annexure, annexure?
Annexure 10, my lord.
Page
24.
24.
This is the proposal, my lord. Sent by the inspector of the school, my lord. But till date, no decision has been taken, my lord.
That is not the procedure. You have to place before the district selection committee.
Also under the new act, Your Lordship,
Hmm.
because the earlier act has
Yes,
been
ma'am.
struck down, Your Lordship.
So this is under the act or new act?
Yes, my lord.
Huh?
Let them take
You are
decision. my lord.
seeking provincialization under the new act or old act?
Already post is sanctioned, my lord. Kindly say
Sir, I am
what's the-
asking which act?
Under new act, my lord.
New act, yes.
Okay. Lordship, my instruction is that under the new act, the process has not been started for the dropped employees, Your Lordship. So this is my instruction, Your Lordship.
Hmm. Yes, you are dropped.
Yes, ma'am.
So they are saying that the drop features, so far as the drop employees, the process has yet to be started. There is the question of consideration. On what basis you are claiming? On what basis you are claiming, sir?
Lordship, kindly say annexure 4, my lord. This is the post is sanctioned post, my lord.
So
Earlier post was sanctioned, my lord.
are you challenging the earlier?
No, my lord, I am not challenging this, my lord. Let them, direction may be given to the DLC for fresh,
No, we cannot until the time they. In that case, you file an affidavit. Or Mr. So-and-so, learn counsel for the petition. MS
D. Musahari,
D. Mushari, learned counsel, state council.
Secondary
State
education.
council, secondary education is granted for the 3 weeks time to file affidavit.
Lordship.
Most of them, give it time.
Obliged.
May I please, the Lord?
Yes.
My lord, the case of the petitioner is that, my lord, and school was established over the property, ancestral property, my lord. Thereafter, my lord, the said property of the land has been divided between the brother, which subjected a civil suit also, my lord, that has been decreed. Now, my lord, the property, the land over which the school was standing, my lord, that has been divided amongst the brother and sister. So we want to close the school. So we approach to the authority also, my lord, and director also to do needful in terms of, my lord. Then, my lord, one and affidavit also has been filed by the my lord, respond number 3, my lord. He said, my lord, it is up to the school authority whether to continue with the admission process or not, my lord. Basically, we challenge the provincialization order that your lordship will see at page at page 15, my lord. It was a provincialization recognition, my lord. Provisional recognition has been given in the year 1995. Now, my lord, the property has been distributed among the brother, my lord. We want to distribute also, my lord. Our names have been recorded, all brother, sisters, my lord. So we have written to the director also, my lord, then director, respond number 5. He, my lord, in turn written a letter to the authority saying that, my lord, lordship, kindly have a look at page 42, my lord. Page 42, it is our brother, sister, that is the writ petitioner, my lord. We have written to the written director. On turn, my lord, page 43. Page 43, my lord, lordship, kindly have a look, my lord. This is Inspector of School so and so. Subject the official reminder reference to notice dated so and so issued by co-owner of the land in which South Point School is situated in National Highway Silchar is requested to deliver the vacant position of the land where the above mentioned institution are situated. Reference my application number so and so 23. In this connection to my application reference, I beg to inform you that I have not received any communication with respect to any action taken from your end. We therefore requested you to inform the undersigned what action has been taken by the authority. Similarly, my lord, higher secondary part, my lord, that your lordship will see page 44. It has been discontinued. Now, my lord, only high school. Lordship, kindly have a look, page 40. Page 44 of my writ petition, my lord. There is a two part of school, my lord. One is a high school, one is a higher secondary school. Higher secondary, that has been closed already, my lord, page 44. It has been discontinued. Only higher secondary, high school part remain, my lord. So, for my lord, if they get student admitted, my lord, it will be havocsome. So, for the new student, my lord, we had a discussion to accommodate them in other school, my lord.
So you want basically to the recognition of the school?
Yes, yes. The recognition
What is
of
the
the
procedure for the recognition?
My lord, it was a provisional and first and foremost procedure is that, my lord, school has to have their own land. Now, my lord, land has been ancestral property. It has been divided between brother and sister. And rest brother, sister, they do not want. Private respondent number 5, who is the director, my lord, let him take his school somewhere else.
Who he is?
He is also one of my brother, earlier director.
I appear for respondent number 5.
And I filed an IA also, my lord, for interim protection, my lord. Lordship, kindly have a look my interim application.
Any pleadings are complete. Lordship, pleadings are complete. Lordship.
My lord, interim application is there, my lord. That has to be decided. IA, my lord.
What IA?
Lordship, kindly have a look that IA, my lord.
What interim order?
I have prayed for a stay of the operation of the recognition, man.
No.
Because, my lord, it is already decree in civil court.
Huh?
The property in respect of the school, the building, there is already decree, my lord. It has been already been given, and now school is not removing, my lord, because of this.
Degree in your favor,
Yes, all brother, sister.
including respondent 5.
Yes, yes, yes.
So
His part is there, my part is there.
it's
our
between
petition
you
is
and your
there.
brother, respondent number 5. Sort it
Respondent
out.
number 5,
Sort it out.
he's also one part.
So
We are
what do you want?
My lord, my instructions are that we have not given any fresh admission, my lord. The students who are there right now in the school, they are all who have been promoted.
You want to continue the school?
My lord, I'll take instructions.
No,
It's
no,
a private
okay,
school.
he cannot continue. It is not his property alone.
Including him only.
No, no, what is
The property belongs to you,
belongs to
including
two
him.
brother, two sister. One of them is their brother.
Yes. He's also the owner of the property.
One part.
Yes.
One part.
You decide. You cannot decide this. School is private school.
Yes,
my lord.
private.
Private school.
That's why I'm asking you, what is the procedure for de-recognition?
Recognition, my lord, it has to be direction by the court, my lord.
No, no. How can this?
There is no other express provision, my
Where
lord.
it
It
is?
is the government.
So, if there is no procedure for de-recognition, procedure for de-recognition, what is the question of we directing them to de-recognize?
No, my lord, I challenge the recognition because recognition was given in the name of father. He was the owner of the property. Now, my lord, first let them show where is the property now. Property has to be there.
No,
School building, land and building has to be there, my lord.
See, recognition was given to the name of your father,
Yes,
who is expired.
the expert.
Now, decree is in your favor, including respondent number.
Yes,
It's your dispute only. It's already, what is the recognition?
recognition lordship will see page, it is given by the government, my lord. It
Let
is
us see it.
annexure 1, page 15.
Board of Secondary Education.
My lord.
Present decision of the board on fulfillment of regular institution and the following has been issued with the permission to present things to the regular subject to the condition.
Provision is there. Yes, sir. He has already written letter to the authority for discontinuation. But that has not been considered. As a result, my lord, we are brother and sister are suffering, my lord.
Who is written?
Private respondent number 5, my lord, the then director. He was the director of that school. He has written letter to the authority for discontinuation, which I have read just now, my lord. That your lordship will see at page 43. 43. That has not been acted upon. If it is not acted upon, my lord, the decree which have been obtained, it cannot be affected. Page 40 is the decree, my lord, though it has got to the Lok Adalat, compromise on Lok Adalat.
What is that? Board's regulation. Board's
Regulation, my lord,
regulation for
it is,
recognition of high school.
it will be the board will have.
My lord, here, my lord, we have filed our affidavit in opposition, my lord, clearing our stand. My lord, the difficulty to withdraw the provisional recognition, my lord, because, my lord, there for the session 2023-24, my lord, there is 8 numbers of students in class 10 and 25 numbers of students in class 9, my lord, enrolled candidate. So difficulty is there. If they otherwise stop the process of enrollment, then board may stop the.
Now it is 25, 26, my lord.
My lord, kindly see the report, my lord, at page 48, my lord. Affidavit in opposition filed by the respondent number 3. Communication to Managing Director, South Point High School, Silchar, by the Secretary, Board of Secondary Education, Assam. At page 48, my lord, and report by the Inspector of School at page 49, my lord.
Those good student, my lord, we have already had a talk with other school.
Yes,
to
one by
accommodate
one,
it.
sir.
Only difficulty is there.
It will be
I
beleg
have the
school.
honor to submit the enrollment question plus 9 into the short form description.
What will
So what is your difficulty?
My lord, they are already enrolled student in class 9, my lord. 20 numbers of student in class 9 and 8 numbers of student in class 10 for the academic session 2023-24, my lord. If they stop the process of enrollment of the student in their school, my lord, then board may stop the provision.
For those 10, 20 student, my lord, we had a talk with other school. Lordship will see page 22 of my IAM, my lord. Of my IAM, my lord, to be accommodated in some other.
You first stop.
My lord.
You first stop the enrollment and
we can withdraw, my lord.
They will consider.
My lord, it is the
The
private
student
school
will
number
suffer.
5, my lord. Government has to act upon, my lord.
No.
He has already written a letter, private respondent.
So what? You are enrolling the school or
I am not enrolling, my lord. We are not interested for the school, my lord.
So
We are not
until
interested.
you cannot, the student cannot be allowed to suffer.
Yes,
No, my lord, we are not making them suffer.
You may not
Kindly
be-
have a look.
But your brother is enrolling.
No, my lord. Why brother will do my ancestral property? There is a
He
decree,
is
my
also
lord.
part of the.
Yes,
he's also
his part is
co-equal
only
sharer.
13 lacha.
His co-sharer.
He's the co-sharer, his portion has been divided. Mutation has been given. His part is different. Lordship
Give
will
him the instruction. Otherwise, nothing. You stop enrollment.
direction be issued to him, my lord, not to cause any further admission for the current session.
Not Mr.
Jai Bharatiya.
Jai Guru, learned counsel for the petition, and Mr.
So DK Roy for respondent number
DK Roy,
3.
learned counsel for the petitioner.
Respondent number 3, my lord, Seba.
Huh?
Board of Secondary Education.
Learned counsel for Seba submits that in the school of being, school is continued, is school being continued to enroll the students, comma, the request for the recognition of the school cannot be, is not permissible.
Yes.
Mr.
P.R. Sharma on behalf of Mr. G. Alam.
Counsel for the respondent number 5.
My lord, on behalf of
Submits
Mr.
that
G. Alam.
he may be granted 3 weeks time to
My
obtain
lord, 3 weeks too long, my lord, session will start. my lord.
Obtain instruction from his client as to whether the school would continue to enroll or not. Since he has already
No,
submitted
my
for
lord,
the
he has
recognition-
already stopped, my lord. He has already given
So
letter
who
to
has
the,
done this?
he has done to
Who
the,
is running it?
running, my lord, is under his control,
So
under his control. And for
See.
other student, my lord, lordship, kindly have a look. Page 22 of my IM, my lord.
list
For-
after 3 weeks.
My lord, a date may be fixed, my lord. Any date, my lord.
It's just a property. We cannot allow the interest of the student is more.
My lord, I have protected the
more
interest. Lordship,
important
kindly
than-
have a
No,
look.
no,
Page
it's not
22.
your choice.
My lord,
It's not your choice, it's the choice of the students, which school
student
they would
choice,
like to
we have
go.
already decided to
No, you
accommodate
cannot
some
force
other
them.
school.
It's
my-
just a property, your property is there. Your brother, you talk to your brother. Don't enroll a student, you tell him. You
Lordship,
said he has returned and the school is under his control. He continue to enroll the student. Then you want that the court should pass an order, they recognize it.
My lord, I challenge school was
Thank you,
recognized
sir.
over
We'll
an
see after
undivided
3
property.
weeks.
Lordship, kindly have a look, page 22, my lord.
It's all right. I'm not passing any order.
Lordship, a date may be
The
fixed, my lord.
students' interest should prevail.
My
over
lord,
your
that is,
individual.
we have protected the
Your
students.
only interest is your property. The interest of the student is their future.
My lord, student of the, we have
Who is the
already,
future of the
we
nation?
have already,
Thank you. Next,
Lordship, fix the date, my lord.
3 weeks. Come up with instruction.
Make your lordship. Lordship, the matter relates to whether the petitioner is entitled to all pension scheme, lordship.
All the new scheme.
Lordship.
Okay.
It is a covered matter, lordship.
Yes.
And as on the last several times, lordship, the response authority sought time.
Which is cover, which method, which case? You are
Lordship,
relying?
WPC 6480 2021 already.
Is it
Honorable-
covered?
My lord, in this case, my lord, Purnima or a judgment, my lord.
Huh?
Purnima or an others judgment, my lord.
So
The honorable court directed that only the stipendiary teacher will get the benefit of old pension
So
scheme, my lord.
whether he is a stipendiary teacher.
No, my lord, he is not stipendiary teacher.
Lordship,
So we
it's
have filed our
common case.
affidavit and we categorically stated that they are not entitled for old pension, my lord.
We say, according to you, it's not a covered case.
My lord,
It's not a covered case.
already decided, my lord.
Kindly peruse order dated 29/1/2025, lordship. After they have filed affidavit, lordship, this order was passed.
Director will file an additional after giving reason as to why the petition should not be given petition before the assembly in view of the fact that similar questions in a bunch of different have been given petition as per the assembly. Additional affidavit.
Lordship, the category that have been.
He may be granted 2 weeks time to file his affidavit and its opinion and to obtain his procedural order of this court. So Barpujari, where is Barpujari?
No, Lordship, Mr. Bopujari, he's on next Lordship. We have received our instructions here in the finance department where we are rejecting the claim of the petitioner as he has been, his services has been provincialized after 1/2/2005, Lordship. So as per the OM that is available in the finance department, people who are provincialized after 1st February 2005, they will be governed by the new pension scheme. So, Lordship, I grant 10 days time, Lordship, I'll file my affidavit.
What is your prayer here?
Lordship, here prayer is that Unima Hore judgment that my learned standing council education has apprised before this Lord. This does not cover our case, Lordship. Our case covers by the judgment which I have annexed, Lordship. That is at page 33, Lordship. That bunch of writ petitioners in that particular case squarely covers our case, Lordship. So education department has to file an affidavit whether we are entitled to for pension.
Similar relief.
Relief, Lordship.
As provided in the writ petition number, bunch of writ petition number
7873 of 2015, Lordship.
8694 of
Lordship, same
2018.
writ petition, Lordship.
So why a different number?
No, there are 3 or 4 writ petition, Lordship. It starts from page 33, Lordship.
Yes, we have taken a time to file affidavit.
Yes, my lord, we have just received our instructions, my lord.
Saying what?
My lord, regarding my lord, that petitioner is not covered under
The
the.
problem is that whether this writ petition 8694 is, it's covered the present case.
That is
The
the question to be
judgment and
decided,
order.
Lordship.
Let me
This
find
day
my.
after tomorrow. You
No.
find it, you have annexed this,
Lordship,
Judgment order,
Annex D, page 33, Lordship.
page 33.
But we have received the, my lord, parawise
No,
comments.
no, first, you tell you with your paragraph comment and this. Whether this writ petition is the see, order dated 29.
29.
Yes.
29/1/2025.
Yes, my lord, we were given the liberty, my lord, to file an affidavit, my lord. So on the strength of this order, my lord, if lordship allows us to file an affidavit. My lord,
What I wanted to know, why unnecessarily keeping it pending if these orders are, if these orders covers the present case, why unnecessarily? You cannot dispute that.
no, my lord,
Other you show that this is not covered. There is
therefore,
a difference.
therefore, my lord, therefore, since this order is a part of the writ petition, and my lord, we will be traversing the, my lord, averments made in the writ petition. I am just paying for 2 weeks' time, my lord, to file our affidavit. That much, my lord. I don't know why he is in a hurry, my lord.
I have not objected to his prayer, Lordship.
No, I just wanted to know either whether,
I have not
according to you, it's
objected.
not, it doesn't cover.
My lord.
It's not covered.
No cover.
What
Lordship, may I
Mr.
submit one
Soito,
thing?
learned counsel for the petitioner. Mr. R. Borpujari, learned standing counsel, finance department. Press warrant is granted further 2 weeks time to file affidavit as directed by this court on 29/01/2025.
My lord, my lord, my
It's
lord.
after 2 weeks.
I'm so obliged.
We'll see.
Lordship, can I get me fix that much, Lordship?
We'll see. 2 weeks.
My lord, I'm so obliged.
Obliged.
36.
In this matter, I have received instructions today morning, my lord. So I need some time to file our
Third MS learned counsel for the Mr.
B Talukdar.
B.
Talukdar for elementary education.
Standing counsel.
My lord,
Oh,
elementary education.
elementary education. Press warrant granted further 3 weeks time to file affidavit.
Obliged.
Yes.
Yes.
The matter relating to my lord, when in the Ames rule, my lord, the basic qualification for the post of my lord, laboratory technician is my lord, BSc in laboratory technology or my lord equivalent.
Pleadings are complete.
My lord,
Pleadings are complete.
complete. Complete.
Mr. Swenson, and Mr. K. Gogoi, learned additional senior government.
CGC, Lordship, Central Government.
Learned CGC. It is stated about the living set complete. Next one.
Well, admission hearing, my lord, otherwise very urgent, my lord.
Huh?
Otherwise it will be infectious, sir.
List after 2 weeks.
1 week, my lord.
3 weeks. We have fixed so many methods. 2 weeks. We'll see.
Diplo. 30th Lordship, we pray for filing affidavit, Lordship. Yes, that my lord 31/5/17.
Huh?
31/5/17, my lord, second. 31/5 years 17, he was preferred a writ petition for claiming pension, Lordship. That was negated, Lordship. And against that. Because my lord, provident fund amount was not, my lord, deposited because my lord, pay protection was not given, my lord.
Mr. K. Gogoi, learned additional.
Standing Council Higher Education also.
Standing Council Higher Education, based on an granted for the 3 weeks time of file affidavit.
Always.
3 weeks.
2 weeks, my lord, 2 weeks. It was my lord, filed on last year, my lord. 3 weeks, we will file, 3 weeks. More than 1 and 20.
May it please your lordship. Lordship, senior counsel K.N. Chaudhary is appearing in this matter. Lordship, senior counsel Chaudhary is currently engaged before a different court. Lordship, time may be given some other date.
On the prayer of Mr.
T.
No,
Kashyap.
Mr. Surenso, learned counsel for the learned counsel submits that Mr. K. Chaudhary, learned senior counsel, is engaged in some other form. Therefore, the letter may be listed after 3 weeks.
K. Gupta, appearing on behalf, respondent 3. K. Gupta, respondent 3.
K. Gupta, learned counsel for the respondent, has no objection from prayer. Prayer alone, list after 3 weeks.
Much obliged.
My lord, in this case, we filed an IA for vacating the, my lord, interim order. That IA is required to be disposed of, my lord.
Why?
My lord, because IA has been filed long back, my lord, on August.
What is the
20
matter?
My lord.
My lord, prior to my learned proceed, may I submit, my lord?
Yes.
The petition have been, my lord, selected, my lord, following the, my lord, Assam Land Record Subordinate Service Rule 2023, my lord.
Yeah.
So that rule has been, in respect of application is in BTC area, my lord, been under silence, my lord, in the division bench, my lord. So, my lord, the learned advocate from the BTC, my lord, took time to file an affidavit, my lord. Whether, my lord, that law has been adopted or not, my lord. Therefore, yesterday was listed for admission, my lord, and it is supposed to be come after, my lord, 4 weeks, my lord, to file an affidavit. And, my lord, any decision, my lord, come from the division bench, my lord, bearings in this case, my lord. May I pray for, my lord, 4 weeks adjournment, my lord?
My lord, I have objection to such prayer, my lord, because in the writ petition they have filed, they have not make any whisper about the that law, my lord, that provisions, and they are directly challenging our selection, and they are also paying for allowing them to go for training. They have no whisper at all about that, my lord, and that provision. They, as per that provision, everything should be, my lord, totally changed since 2010. How it can be, my lord? Entire BTC will be collapsed, my lord, if that procedure is followed, my lord. My lord, in the present case, is dispute is whether they are entitled or we are entitled to go for training. In fact, my lord, we are allowed for training through a process. BTC took resolution. There was an advertisement, selection. Then we are allowed and we started training course. After 1 month of training, because of the interim order, in the case, my lord, our training also, my lord, stopped, my lord. We are now ousted from the training. Therefore, we are seeking.
What is training for?
My lord.
What is the post?
Post is, my lord, it is a, my lord, recorder's certificate class course training.
Undercourse is training.
Yes, my lord. 6 months training course, my lord.
This is the qualification for Mondal, my lord.
After the training, you will be automatically.
Mondal, my lord. Yes, no.
You will be automatically appointed.
No automatic.
There is no urgency. So what is the issue? Why you are, on what ground you are challenging?
My lord, challenging my lord, here.
Challenging their selection.
My lord, not exactly challenging the selection, my lord. Here, my lord, they have been selected, my lord, as per Annexure 7 of my petition, my lord, by Annexure that advertisement, my lord. So these advertisement in under silence before the division bench, my lord. Because the BTC authority cannot issue this advertisement without adopting the law which is applicable in state of Assam.
List 1201/2024. This influence finance merit list is pursuant to the advertisement.
My lord.
Which is under challenge.
My lord, the advertisement and the rule, my lord, under which the advertisement has been made.
Before the division.
Before the division, but I have provided the order, my lord.
Yes.
They are also party, my lord. They are the opposite party.
My lord, in the writ petition, they have not made any prayer against the advertisement, my lord.
No prayer may not be made. He is not challenging that they are challenging the advertisement. What he's saying is that the advertisement and the rules under which the advertisement was issued is a subject matter of challenge before the division bench. So your selection is based on that selection advertisement.
My lord.
We'll wait for some time.
My lord, absolutely no pleading in his case, my lord.
It's okay.
My lord, the beyond pleading, my lord, how that can be dragged here, my lord?
It's applied in civil proceedings, civil cases.
My lord, they have not made any whisper against the
read court.
My lord.
Order I have provided, my lord, therefore yesterday passed. They are also party, my lord, respondent, my lord, in that.
It's okay, but then what is your ground? I'm asking.
My lord, challenging that vision bench, my lord.
No.
Here, my lord. Here, my lord, the as per rule, if suppose the rule is applicable, assuming to be in BTC area, my lord, they cannot advertisement, they have, the contradiction is there in the advertisement. They have said that the lease will be valid up to 2026 March for 3 years. And the actually as per rule, if it is applicable, they have to advertise against the post, vacancy of post. Not, they have selected 150 people. Whereas even they are not
Selection is only for training.
Training also, my lord,
for appointment.
as per new rule, though the new rule has been not challenged here, my
How
lord.
you want to go for training?
My lord, as per new rules, my lord, this is training is after selection. This is a training will be post selection.
What is the process of selection?
Process, may I provide them a rule, my lord? This is the rule, my lord.
No, it's okay.
As per the rules, they have to, according to the vacancy, they have made a selection. After selection,
have you
they will go for training.
Sir, have you applied for pursuant to the advertisement?
My
Have
lord,
you applied?
who has, my lord, moved before the, my lord, division bench, they are already, they have, my lord, have that RCC training certificate, my lord. On that ground, they are saying that we have already completed. So without observing or without following the due procedure law, again you will send 150 people for training.
Up to them. Who are you?
Well, because, my lord, we have been also selected, we have completed our training, my lord. And that rule is not applicable in BTC area, and which we were selected, that is was applicable at that time.
The training.
My lord, I have completed training.
So
remember, they are make party, my lord, being selected anti-advertisement under silence, my lord. And this respondent, my lord, BTC have take time to file the affidavit, my lord.
My lord, that is a separate issue. That will be decided separately.
That is your ground, that the rule doesn't provide.
My lord.
The rule is not applicable.
Not applicable.
It's a relevant, I mean, the matter is pending before the.
My lord. Well, maybe after 4 weeks, my lord, I have
No,
to
division bench.
My lord.
So why the writ petition, separate?
My lord, separate. My lord, that he's been filed few days back, my lord, because after getting the.
Close this in view of that. We
Yes,
close
my
the writ petition.
Yes, my lord.
If the similar matter is before the division bench, that's why I'm asking whether on what ground you are challenging.
My lord, here challenge is different, my lord, against their selection, my lord. The procedural effect is not here, my lord, in the division bench, my lord.
What is your ground?
Ground is here, my lordship, may come to my then first, my lord.
See, you cannot blow hot
No,
and
here is the petitioner is different, my lord. There petitioner is different.
you are saying that the petitioner, you say that the rule cannot be applied
My lord,
in the BTC area.
my lord.
At the same time, you cannot rely on the rules. That
I'm
is
not relying, my
respected
lord.
rules,
I'm
huh?
not relying, my lord. That is what here I have not challenged. Yeah, I have to challenge, go to division bench. Therefore, it is not challenge, but facts are there, my lord.
No, you are saying that this is, you said the advertisement is not in terms of the rules.
My lord, here is petitioner is different. Their petitioner is different, my lord.
Initially, one of their PTC has been selected on 219 They are one of the that is selected. After that, 150 has been selected. They have challenging dates for 150.
They have been also selected.
They have also been.
They have undergone training.
They have not been sent to the undergo training. Their name has been forwarded. Subsequently, this list has been come. They are not allowed to go for the training, and the subsequent list they are allowed to participate in that.
How it is possible?
Lordship, I am appearing for BTC Lordship. We have filed affidavit stating the fact, Lordship. They are 210. They were on 219. They were made selection by the secretary without advertisement, proper advertisement. And second batch is 150 is selected through due process, Lordship. Following the rule, Lordship. Therefore, they are genuine, Lordship, as per our view. And Lordship,
the applicability or otherwise of the rules is before the division bench.
My lord.
No, you have been selected, right?
My lord.
Without following the rules.
yes, Lordship.
My lord. They said, my lord, I am denying that, my lord.
So what do you want for your denying? Any advertisement was there?
No, my lord. Earlier, the rule involved in BTC, my lord, they used to call, my lord, who are qualified. According they have there's even last several years, my lord.
What rule says?
But earlier rules, my lord, according to earlier rules, they have selected us. Yes, there is a deviation, but earlier rule they have selected. But present rule, my lord, those people are selected, my lord, because all the, my lord, training schedule has been, my lord, prepared for us, my lord. So we are supposed to join on the 17th of my lord,
Your
January.
selection was not in accordance.
But they have been not approved by the BTC. They have selected. They have not approved by the BTC, and this government of Assam also not made any, my lord, this schedule scheme for their training, my lord. They have come in our scheduling, my lord.
Lordship, kindly.
Where is the interim order?
My lord, in my miscase, my lord.
We're vacating the interim order.
Yes, my lord. In IA
My lord, it's among my lord, this is the main case, my lord. Because my lord, my lord, bear with me, my lord, because it's amongst them, I have objection, my lord, file objection in the IA, my lord, in the ground number 2, my lord. It's amongst to, my lord, deciding the main writ petition, my lord.
Right.
Because if they are allowed to go, I'll be deprived because all the schedule has been made only for us, my lord. Only for us. Lordship may come to my writ petition, my lord. I'll one by one, my lord, I'll hit it. Bring to Lordship, my lord, notice, my lord.
Status quo
status quo
Only there is a status quo order, my lord. Neither they are here nor we are here, my lord.
Then we'll clarify that those.
That's why, my lord, after 4 weeks, my lord, let my division bench must take a call, my lord, in this issue.
The persons who have been selected in terms of the advertisement as per the rules, they are allowed to undertake the training.
My lord, there will be a contradiction, my lord, because the advertisement has been under silence. If the advertisement goes, my lord, this order will be, my lord.
Okay, it's not
Judicially, my lord.
They will have the privilege of having.
No, let them come, my lord, OF orders, my lord, because it come on the admission, my lord. I thought it is an admission matter, orders, let come the orders, my lord. It is an admission matter, my lord, if they are moving the IA, my lord. In orders item, my lord.
Have you filed any objection?
I have filed objection, my lord.
What is your ground? What is your ground?
Ground, my lord.
What is the other writ petition? 387.
387, this is a first case, Lordship.
Well,
Their
that was
status was given, Lordship.
This order has been given.
Original one lagay, original.
I think. 43.
Kindly peruse WPC number 387, order dated, Lordship. Order dated 5/2/2024, Lordship. On the same day, status quo was issued and training also stopped, Lordship. Actually, they should give to continue the training, Lordship, because of status quo order. But they have stopped to join training. Stop করে দিল, stop করে দিল। এগুলো training period also। Stop করে দিল তো।
Yes, what is the ground of your challenge?
My lord, ground of this, we have been selected. They are saying that our selection
What
is
not
not
this?
according to,
Huh?
my lord. Then, my lord, they have sent to the government of Assam for training. Accordingly, government of Assam, my lord, Revenue and Disaster Department make a, my lord, schedule. Their schedule is for us. When
We'll send the schedule for them.
no, lordship, all the documents only for us.
We'll send them.
So they cannot come. Then if they are eligible, they will have to
allow
come
them to-
subsequently, not in my place.
We'll allow them to go. Because privacy, your selection is not in accordance with the rules.
Yes, Lordship, kindly peruse my affidavit.
Neither their selection also according to rules,
Let
my
let
lord.
me know.
Neither their selection also according to rules. We
Kindly,
will go,
kindly,
order to go, my lord.
kindly go through my affidavit.
They are also not in the rules, my lord.
Why?
Because
This
lordship,
advertisement was issued.
my lordship is advertisement, difficulty in the advertisement, my lord.
Kindly peruse my.
Lordship may come to my repetition, my lord. Advertisement, my lord.
What, Mr. M. Saradia, learned counsel for the petitioner. We'll dispose it of next week
Yes.
on Tuesday.
Yes.
Learned counsel for the
My
petitioner.
prayer is to 4 weeks, my lord, after 4
Huh?
weeks, my lord.
We'll dispose it of.
Because
Maybe.
the division bench,
We're
my
not
lord,
saying that, we said we'll hear it and dispose it of. We're not saying that we'll dismiss the writ petition. Why was scary? Why you are so
and only
afraid?
things, my lord, division bench, any order is
No,
bearing
no,
on this
your-
petition, my
your-
lord.
Your case is something different. You wanted, since you have been selected and all the preparation has been made in for your training,
My lord.
you should allow to go. I mean, continue.
Yes,
to
we should allow-
undergo the,
continue,
you should
my
be
lord.
allowed to undergo training.
My lord.
Their case is that the selection which you have challenged is in accordance to the advertisement and the rules.
Yes.
So your appointment or selection was not in terms of the rules. We'll see whether your selection, their selection is as per the rules. Whoever been selected as per the rules will prevail. Better and safe.
Then may come for orders, my lord, for IF.
No, admission. We'll dispose it of them. Nothing. Very simple. I believe in simplicity, including the. Including we expect. Therefore, I expect the learned lawyers to be very precise and simple.
My only
As I
anxiety is, my
repeatedly
lord, the
said
division bench, my lord.
other
If
day also, Mr. Sarania, these are gone. The craft has to be adapted in tune with the AI.
that also some giving
Or a
wrong information,
technology.
my lord.
Not that kind of.
I am using, my lord, not that much. They are not even, my lord, percent a human brain, my lord.
No, maybe. But not those all.
Last 1 year, I am, my lord.
Outdated. I mean, the kind of the practice. Let us move ahead.
My lord, let me choose the date, my lord.
No, next week.
Next,
Tuesday.
my lord.
Not Mr. M. Saranya, learned counsel for the petition. And MS and so. Has agreed to a learned counsel for the parties. Let this matter be listed for final disposal next after a week. Another date maybe after a week.
20.
We're fixing
22,
it. I have spent a certain amount of time, therefore I'm fixing it for
20 plus.
disposal. Yes, next.
20, my lord.
Deeply obliged.
March 25th. My lord, may can be my 27th, my lord.
27 were
Thursday.
60 millimeter.
Thursday, my lord. I outside my lord on that day, my lord.
27.
Yes.
I know.
Maybe a lot, my lord. My lord, in this case, I am appearing for private respondent number 4, my lord.
Yes.
And I shall file affidavit, my lord.
What is the matter?
My lord.
My lord, he is not qualified, eligible for holding the post of in charge headmaster of the school, my private respondent, my lord.
Yeah.
For not having the B.Ed degree. And I have acquired the eligibility criteria, my lord, and I do fulfill the, as per the rules, my lord. Therefore, my submission is to allow.
Respondent number 4 has been appointed as headmaster.
In charge. In charge.
In charge? What is there? It's an in charge.
In charge.
So,
my lord, for in charge, even my lord, as per the settled position, my lord, one must have to possess the qualification.
so the rule, so the judgment.
They have not brought.
Today better is listed.
In the morning, my learned friend told me, my lord, we'll take that.
We'll say it is true that even for in charge.
Yes.
The seniority and eligibility has to be looked
Yes.
into. However, the method is only for in charge. What is that appointment for in charge?
It is, my lord, impugned page 26. 26. Jagannath Singh.
Along with Provincial joint It's of 2023.
Yes, sir.
On retirement of Fazil Haq.
Yes, madam.
Earlier.
So you are continuing.
Yes, madam, I'm continuing now. As in charge headmaster.
Why in charge? Why not regular?
Regular process has been initiated by the department, my lord, throughout the state of Assam. It's on the way. It will take time.
It will take some time.
So, my lord, the Jagannath Prabhu settled judgment, my lord, I will give the citation, my lord. It says that as per, even for the in charge, my lord, one must have the requisite.
Settlement has been, the regular process has been initiated.
Initiated in the year 2023 itself, my lord. Till now it is under process.
Our Mr. Learned Council could be decided. And also, have you filed the affidavit?
Lordship, here
And
Lordship, the representation that has been filed by the petitioner, your lordship, that can be considered by the director, your lordship.
I'll
So
file
that
affidavit.
Director is the authority, your lordship, because here, your lordship, the impugn order was filed.
Although, although Mr. M.S.
D. Musahar.
D. Musahari, Learned State Council,
Secondary.
Standing Council Secretary submits that the representation filed by the petitioner may be directed to be disposed by the respondent.
Page 27, your lordship.
My humble submission, my lord, that I shall file affidavit, my
In
lord.
view of the vehement objection by Mr.
A.R. Talukdar.
A.R. Talukdar, Learned Council appearing on behalf of Mr.
Respondent number 4.
Further, a week's time is granted.
2 weeks time, may kind of.
1 week.
My lord, my lord.
2 weeks time is granted.
Obliged, my lord.
Mr. Talukdar to file affidavit.
My lord, my lord.
Next week, what is going to do?
Highly obliged, sir.
Yes.
May please, your lordship. Your lordship, the advertisement is page number 29.
Yes.
Yes, lordship, the last date is 18 and we are working under A&M since 13 years, your lordship, and our age limit is over, your lordship. But we have duly applied, kindly allow to us for participate by interview, your lordship.
Where it is? Advertisement? Advertisement?
Advertisement is page 29,
29.
NXRC.
Why you have been debarred? Have you been made ineligible?
No, lordship, actually our age is over, your lordship, as
So,
part of
What
advertisement.
can we do? You're in luck.
Lordship, we are working since
You cannot
13 years.
stop the age.
One is the similar,
Yes,
similar.
what is this? Online application, or 600 vacancies, great fee post. Existing with different health insurance. Yes. So you are overaged now.
Yes, lordship, and
So-
we are working under A&M since 13 years. Temporary, your
Is there any power of relaxation as relaxation?
Lordship, here I have a similar order, your lordship, on page number 42.
42.
Yes, lordship. Similar order, your lordship.
When is the last day?
Last day is your lordship 1812, but we have applied, your lordship.
You have already applied.
Yes, before 18 we have applied.
When is the interview?
Interview, your lordship.
Your case has been rejected. Has it been rejected?
No, they have no any rejected, your lordship. This case is pending, your lordship.
What is the procedure? Yes, Mister.
Lordship, there was an advertisement issued on 6/12/2024, Lordship.
Yeah, 5/11.
Yes, Lordship. And then last day was 18/12/2024.
Ah.
Thereafter, Lordship, the persons who were overage, Lordship, they have approached this honorable court. And then, Lordship, this honorable court was pleased to pass the order dated.
In respect of only two.
Yes, only this 34 people, Lordship.
Yes.
And then, Lordship, we have allowed them to participate. They participated and the written examination was also over on 12/1/2025. So now just the results are awaited, Lordship. So they didn't come on time, Lordship.
Written is over.
Yes, Lordship. Nothing remains.
Can you give us some relief, your lordship?
No, it cannot.
Because we are working since 13 years.
Sir, madam, we cannot start the clock back.
Can you give us some relief, your lordship?
It would have come earlier. At least before the
Last day.
the written exam. The written exam is over.
No, order.
Written, Lordship. On 12/1/2025, written was over. And only these people, Lordship, who approached the court on or before 1812 were allowed to appear before the for the written examination because they were also overage. But
Are
this
you
petition,
sure?
yes, Lordship, I have the instruction. And Lordship, similar petitions.
It's a working certificate, your lordship.
No, we understand.
Lordship,
Your
this is a
comment
sim-
disputing. Problem is
Lordship, this is an order of a similar
applicants are overaged. Right.
Lordship, these people, they approached before on time, Lordship, and we have allowed them. And this writ petition was disposed of since they already got the relief, Lordship. They appeared before the in the written test.
But not come to list, your lordship. This is not allowable, your lordship. We have already filed, your lordship. This is
Filed after the last date. Lordship.
But before the last date, we have already applied, your lordship. We have expensed all the due or fees also, your lordship.
It's okay, your application, nobody is disputing, but problem is interview
Where
is
is
over.
Where is the application? Lordship? Application code.
We cannot direct, since you are admittedly not eligible, overaged, we cannot direct them to have a special interview. That will not be permissible. Yes, what is to be done?
Dismissed.
Have you filed your affidavit?
No, Lordship. It's not required, Lordship, since Lordship already the written is over, Lordship.
But there have a similar order also, your lordship, and we have submitted their kindly give us for time for filing the affidavit.
What affidavit?
What affidavit?
Why you have not prayed for interim on 18/1?
Yes, lordship.
Because, Lordship, the written was over on 12/1.
Yes.
And 18/12 was the last date to apply. And they did not
18/12 is
apply,
the last
Lordship.
date.
Yes,
They
18/12.
applied.
No, Lordship, where is the application? They could not apply, Lordship, because they're overage. They should have filed an application for condonation of their age, Lordship, to the department.
When is the interview?
Written test was on 12/1/2025.
12/1. 18/1. 8/1. You have moved this between 8/1.
Yes, Lordship, but we have.
But there was no application
But
for
we have-
condonation of age.
See, before the last date, your Lordship. So kindly give us some of relief for.
No, actually, at best, we could have allowed you to participate if the written examination is not over. Now it's over. We cannot direct for special.
And we are in the month of March,
Your
Lordship.
Lordship, kindly directed to the state, your Lordship, for
Uh-huh.
participate the interview again, your Lordship.
But interview is over. You approach, you avail the appropriate remedy, taking different, you may, since when you are working.
13 years, your Lordship. And I have submitted the working certificate, your Lordship.
No, it's not.
Annexed in here, your Lordship.
We understand.
Yes, Lordship.
Sorry, MS. Not MS, MAD, Learned Council for Decision. Next period. No. MSM, you can't do it. MSM MAD, Learned Council for the Petitioner. Drawing the attention of this court that the attention of this court to the advertisement dated 05/1/12/2024. Submits that petitioners have, how many petitioners?
Yes, Lordship.
Kiman ase? How
Seven.
much it is?
9, Lordship.
Petitioners have applied for the, petitioners have applied for the post of
Lordship.
ANM.
Yes, A&M.
Lordship, they have not applied, Lordship. They cannot apply, Lordship.
They have applied.
Once
Oh, yes.
Yes, Lordship. They have
submits that
applied.
the petitioners have applied.
Apply কৰিছে দিয়া নাই to apply কৰিছে তেওঁলোকে মই কেনে কৈছে
Submits that pursuant to the said advertisement, the petitioners have applied by submitting their applications list of. However, due to the petitioner being overaged, the petitioners, the responsible authorities have not allowed the petitioner to take part in the selection process, recruitment, the selection process. Is there any rejection against, there's no rejection, please stop. He submits that in the similar situated case, this court has allowed the petitioner in those cases to, in that cases, similar cases in writ petition, so it's page 30. Everyone, in WPC 4340. So this court, ordinance mentioned this court has allowed the writ petitioners. No, this is page 36. 36.
Yes, Lordship.
36, yeah. To submit their application and allow them for in the selection process. First of therefore, she submits that the petitioner may be granted the similar by of entry. Next paragraph, Mr. Upamanu.
Yes, Lord.
And Upamanu.
D.
Upamanu, Learned Standing Council, Health Department.
Yes, Lord.
On instruction submits that the interview has, the last date of application was on 18/12/2024. And the written examination has already been over. The examination was on 12/1/2025, which is already over. So therefore, no entry order can maybe pass. Next paragraph. Having considered that the last date of submission of application was 12, no, 18/12/2024, and the written examination has been already conducted on 12/1/2025. I'm of the view that no order, no interim order would be, no, it would not be appropriate to pass any interim order for allowing the petitioners to participate in the selection process, as the same has already, as the written examination has already been covered. In view of the, accordingly, the interim prayer is rejected. Next paragraph. Mr. D. Provincial counsel for the petitioner. The letter standing counsel is granted for the 3 weeks time to file affidavit. Your interim prayer is rejected. We'll see on merit.
Public.
Public.
Yes, give it this, let us see. You tell me from me. Sorry, madam, it would not be possible. We'll fix some other day.
Yes, my lord.
I'm
In
sorry, my
fact,
lord.
records were called for, your lordship may kindly peruse the last order
Ah.
dated 4/3/2025.
Yes.
They were supposed to file, submit records. Then another, the records are there, so, another date may be fixed.
Have you received the record?
Yes, my lord. The original record, actually, that was misplaced, my lord. Now, the college authority has provided the records, my lord, which are
But
available.
it should be in respect of departmental proceedings.
Yes, my lord, yes. Records.
And MS,
Yes,
MP
the-
Chaudhary Lalit counsel for the petitioner. Due to paucity of the matter could not be taken up. Mr.
As das,
As the Lalit standing counsel.
higher education.
Higher education. Commits that he has received the records as directed by the score on 4/2/2023. They list the matter after 2 weeks.
My lord, this, the date may be fixed because records are
weeks.
there.
Give the date 2 weeks. Then next. When is the meeting? When is the meeting? Okay. 15. Yes.
Better relates to provincialization and service level. Already there is a direction, lordship, to consider my case.
Not Mr.
D. Bhuyan.
D. Bhuyan, Landed counsel for the petitioner. And Mr.
I am from lordship 1, 2, 4 and 5.
PNC, 1, 2, 3.
I am for 3, my lord.
1, 2, 4 and 5.
I am
And
for
for 3.
3, my lord.
Okay. So any other respondent? No.
No, my lord.
By filing this writ petition, the petitioner has prayed for a direction to the respondent authorities to place the case of the petitioner before the DLC. DLC what? District level committee.
Scrutiny committee, district scrutiny.
What do we call it? DLC is what? Full form?
District scrutiny committee.
Huh?
District Scrutiny Committee.
Why then DLSC?
District level.
Librarian scrutiny committee.
DLSC. Demaji. In terms of the Section 13 within bracket 6 of that, what is that? Assam Educational within bracket Provincialization so and so of 2017. 17, right?
17.
For consideration for provincialization of the service of the petitioner as assistant teacher in Babeli, others are in the school. Mr. The name of the school is in page 21. Next paragraph. In view of the simple prayer made by the learned counsel for the petitioner, the read petition is disposed of. We are directing it to the place before the DSC.
My submission will be that there is already a direction. There is already a direction of this honorable court, my lord. If he said agreed by the particular order, he need to file then, my lord, a contempt petition. Against a writ petition order, again, my lord,
It's
direction.
okay, you place it,
My lord.
place before the DSC because requirement.
Otherwise, my lord, one technical difficulty is that, my lord. That, my lord, scrutiny committee, that if any agree in action of the inaction of the scrutiny committee, then against it come to the director, my lord. Therefore, director has take the decision. My lord. Director is the appellate authority. My lord. Any action or inaction against that, he come to the director. My lord. Therefore, my lord, director has taken the decision.
In view of the simple prayer of the learned counsel for the petitioner, this writ petition is disposed of. Simple prayer for placing the case of the petitioner before the district level scrutiny committee, the writ petition is disposed of. Next paragraph. The case of the petitioner, sort of unnecessary details is that this court, this is by you. This is filed by you. This court, by an order dated 21/03/2018, passed in 898 of 2014, filed by the petitioner for provincialization of the provincialization of his service as assistant teacher under the, what is that, all that 2011. You give the name of that all that 2011. 11.
Act will be the Assam Education Institution.
You challenge the, and also challenging the appointment of one Pavitra Chutia. Huh?
In the earlier petition.
Yes. This court, while dismissing the writ petition being not maintainable, has directed the on consideration that the state has subsequently enacted a new act, namely Assam Education within the Provincialization of Services of Teachers and Reorganization of Education Institutions, Act 2017. In the meantime, directed the respondent authorities, not directed, has held that the respondent authorities may consider the case of the provincialization of the petitioner under section 13 within bracket 6 of the said act of 2017, if otherwise the petitioner is eligible. The person there, so the by EP order dated 09/08/2022. The case of the petitioner was considered. No, issued by the Director Elementary Education from a Government of Assam. Rejected the case of the petitioner. On the ground that rejecting, whereby the claim of the petitioner has been rejected. As the name of the petitioner, the suggestion, the name of the petitioner was not recommended by district level scrutiny committee, Demaji. And the petitioner, not being a science teacher, teacher, and all other subject teachers have been appointed from in terms of the section 3 within bracket 1, bracket close, bracket 11 of the Preferential Act 2007. Mr. So-and-so, learned counsel for the petitioner vehemently urged that since the direction was for the direction of this court, that is so-and-so, same date, is for placing the for consideration of the case of the petitioner. Under section 13 so-and-so of 2017, and the petitioner being, you are not science teacher.
Not science teacher.
Same ought to have been considered by this place before the district level scrutiny committee. Therefore, direction may be issued to the responsible authority to place the case of the petitioner for to place before the district level scrutiny committee. Next paragraph. Mr. So-and-so.
Peace
here. Learned standing council.
State government council.
State council. What is your submission?
My submission is that there is already a direction of this honorable court is a writ petition. And against the writ petition, second direction may not be justified. Number one.
No.
And apart from that, there is no mandamus in the order itself.
By this court, by order dated so-and-so, in writ petition so-and-so. Therefore, the subsequent, there will not be any direction again and over the said direction of this matter.
Because alternate remedy is already there.
Yes, sir.
And moreover, it is not a mandamus also, because authority may consider a clause is there.
More so, the order is only for a consideration so that there being a mandamus, so that there be an issuance of mandamus. And the further submits that since the case of the petitioner, although by the director has fairly been considered with the regent's order, even if the direction is passed for placing the matter before the DSC, same would be unnecessary redoing of the same matters by the appropriate authority, and the legality and validity, legality and otherwise of the impute order passed by the competent authority, being the director of elementary education, has been input to Canada. I have considered the submissions of learned counsel for the petition. I'll decide. Because he has raised something substantial. Simply your just because there is an order to place, as I indicated earlier, maybe you are not challenging it. You are not challenging the legality.
The director also passed the order in compliance of the order of the 1714.
But then, so far as the section 13 is concerned, of course, it was at the time of initial stage, it includes the list of all venture schools and other things. But first, it has to be placed before the district. That will clarify. May not be allowed, huh? But that will be. I'll examine and pass down. I mean, complete the order. 2-3 paragraphs more. Public.
Orders 47.
We'll continue.
May I please, your lordship? Lordship, I'm appearing for on behalf of Mr. K. Singha.
Yes.
Lordship, the respondent does not hold his office any longer, so kindly allow us some time to impeach the new incumbent.
Huh? Mr. So-and-so, learned counsel for the petitioner, learned counsel for the petitioner. Press for and then granted 3 weeks time to file appropriate application for implement of the new incumbent. This after 3 weeks.
Okay, sir. May I please, your lordship?
Yes.
Well, matter pertains to provincialization of service of the petitioner
Well,
to the
listed for
LP
order
school,
to-
my lord. My lord, what happened in this case, my lord? The diaspora, my lord, pertaining to the year 2009 and 10, my lord will find at page 21, my lord, and except 6, my lord. The name of, my lord, the private respondent was 6, my lord, did not appear as the, the teaching staff of the school, my lord. Page 21 and except 6, my lord, we can see, my lord.
Not Mr. So-and-so, learned counsel for the proceedings of the Lojama Court dated 12/11/2024. Indicates that as per the postal check consignment, the service of the notice has been duly served upon the respondent. In view of the service in this respondent is complete. This for admission of that follows.
My lord, will kindly give a date, my lord, or she will kindly fix a date. That is my humble family. The date is.
May I please, your lordship, kindly pass over the matter for the time being.
What is for, why is listed for, why this is listed today?
I'm not aware of.
Huh?
Lordship, let my senior come.
Who is your senior?
B. Chakrabarti.
Or MS so learned counsel for the petitioner?
Yes, sir.
Office note that, no, the order of lodgement for indicates. Indicate the notice upon sole respondent has been delivered on 07/12/2022 as per the postal frequency in their order. The office upon the respondent is complete. This after 3 weeks. There's I mean, last time we did Laudema.
Has to submit some
it was
report.
not on that report.
The report is
It's
service is
complete, service complete.
May it please the lordship, lordship, in this matter, I prefer one time lordship.
Contempt.
Although on the earlier occasion lordship, I was directed to obtain instruction from the Director of Elementary Education Department lordship. And
Come up with the
lordship, some
compliance
instruction.
order.
Some
What
instruction.
Mr. So-and-so, Mr.
PN
PN Sharma, learned counsel for the Alice container. Press for
I'm not yet the counsel for the contempt of lordship. I have been asked, I have been directed by this honorable court to obtain instruction. So
learned
Wakalatnama is
counsel-
yet to be
Who is
received.
for the counsel for the Alice container?
No one is appeared. No one is
Court is
appearing as yet,
directed to
lordship.
bring the instruction.
I have been directed to obtain instruction, lordship. So we are yet to file a
Then,
Wakalatnama also.
No. Then you just delete it. Mr. P. N. Sharma, non-standing counsel for elementary education department is granted for that a week's time to obtain instruction as directed by this court on 18/11 as per the order dated 18/11/2024.
Well, lordship, my name may be recorded in the
The-
cause list.
Name of Mr. P. N. Sharma, non-standing counsel.
Kindly
Be reflected from the. So registry to reflect the name of sales, right?
What's up,
Sorry. Registry to reflect the name of Mr. P. N. Sharma, non-standing counsel, elementary education, right?
Well, kindly fix the matter.
That's. After 1 week.
May I please, your lordship?
Yes.
Lordship, as per the order dated 23rd of January 2025, passed by the Lawajima Court, the service has been completed on respondent number 7. This is the
Yes.
only private respondent,
Okay.
others are all the state
What
respondents.
Mr. Sir, order of Lajima Court indicates the service on notice of service. Respondent number 7 is complete. The notice on respondent 7 has been delivered as per the postal freight consignment on 15/01/2024. Mr. India Babu. Service in respect of respondent 7 is complete. List after 4 weeks for admission.
Obliged, my lord.
So this is an application for paying for grant of leave, my lord. Because the internet petition was heard on 30/6/2023. At page 10, my lord. And this honorable court.
Sir, we can
personal-
ask them little. Not today.
Page 14.
Not
left.
today, some other day. All right. This is for what?
For leave, paying for leave of the court to come to a conclusion of logical conclusion of the departmental proceeding that has been initiated earlier and allowed by this court. Already completed.
Ready to complain.
Completed.
It's a formality.
Or what happened is we challenged the proceedings. The inquiry report has come. The report I have submitted before this. That is all.
Due to paucity of time, let it not be taken.
Any other day, my lord, next week or.
Mr. So-and-so, all have and present. As agreed to well, and this came better after 2 weeks.
Interim order continues.
Interim order for LSA.
Obliged.
May it please your lordship.
Yes.
Both are analogous matter. So far, item 53 is concerned service complete, my lord.
Okay.
And 54 is, my lord, and there's a Laudima court order, my lord, that the service to the responder 789 is not complete. I have to take fresh steps.
You take. You take.
Yes.
Which petition? Hard mistake. AMS so and so land council. Lauzima court order dated 03/03/2025. This is petition 4125, huh? 1220. Reflects that as per the postal track concerning reports, the service in this notice in respect of respondent number 7 has been delivered on 10/2/2025. The service in respect of respondent number 7 is complete. Then another, that is attempt 54.
54.
So it's same, huh? MS so and so learning council for the petitioner is granted 10 days time to take fresh steps for service of notice upon respondent number
789.
789. This the matter after 4 weeks.
Maximum.
Sir, what is this?
The report is complete, service report is complete. And there are some serious allegations against some of the respondents, private respondents who are made party by name. Bringing some serious allegations by 2 students. So they have to file affidavit. The report is complete. They have not filed
Yes.
any
Not
affidavit.
Mr. Harpreet Sharma, Learned Senior Counsel, assisted by Mr.
You Ghosh on behalf of DP Bora, Standing Council of Health Department. I am waiting for response number 8.
Eight. Only 8.
Yes.
Office note dated 07/03/2025 indicates that the notice upon respondent number 3678, 367, 9, 10, 11, and 12 has been delivered on 27/01/2025. In way of the service in respect of so and so. It's in the note, office note. 3, 7, 6, 7, 9, 10, 11, and 12. Services in respect of students are complete. List for admission hearing after 4 weeks.
No, my lord, very urgent.
3 weeks.
My lord, let it be after 1 week, 2 weeks.
1 week.
No, my lord, we have to file affidavit.
You may file affidavit in 2 weeks. 1 day affidavit we draft. 1 day file it in 2
weeks.
2 weeks. 2 weeks, my lord.
3 weeks.
Because involving 2 students like my lord, career.
Because it's your no use.
Your lordship,
After 2 weeks, because they will not file.
They will have to file one allegation is so serious against 2 my lord, professors. Professor ragging the students, that is very serious allegation.
Yes, we'll see. We'll see, sir. 3 weeks.
My lord, date may be fixed.
Give the date after 3 weeks. Yes.
56.
What is your lordship? This is a contempt petition, lordship.
Yes. What is to be done?
Against the order dated 22/11/2024. In WPC number 1828/2024.
Well, they'll take it after 3 weeks because Eddie card has received back.
Lordship.
After serving or what?
Step has been taken on.
Yes. Yes, Mr. Boro, come in. Boro, what is it? Hard MS and learn council for this. This is after service. As per office note dated. No, office note dated 4/04/03/24 reflects that the Eddie card has been received in respect of this understanding. The list is better after 3 weeks.
Applies, Lordship.